digital number plates goes beyond simply combating terrorism, war, or espionage. It is meant to address all types of crime in as long as the element of crime involves the use of a vehicle with a registered number plate. The argument presented by government security in this context is that by having a digital record of every vehicle number plate in the country, they will be able to easily track illegal activities as and when they happen, thus smoothing the investigation process and cornering the culprits behind the crime. As such, it is more like a big brother policy of knowing whose hand is in the cookie jar. As to whether this is justified, in light of international and domestic norms, is the question. So by way of background, in February of 2023, the Uganda Police Force released its annual crime report of 2022. The highlight of the report is that crime rate shot up from 2022 by 18%. And this is based on the total number of reported cases in 2022, which were 231,653, compared to 196,081 cases reported in the previous year of 2021. The report further highlights that a total of 1,091 cases of theft of motor vehicles were reported to the police in 2022, while a total of 5,675 cases of theft of motorcycles were reported to the police in the same period under review. So when we're talking about vehicles, of course, motor vehicles in this sense, it's not just cars, but boda-bodas, as we understand them, motorcycles, tuk-tuks, all those that use a motor to run, and as long as they have a number plate. So a further interesting highlight from the report is that out of 24,111 vehicles involved in crashes or accidents, 139 of these were unregistered. This would ideally mean that it makes it harder to resolve such accidents involving unregistered vehicles. The report does not offer any highlights on unresolved crimes or ongoing investigations or prosecution of crimes involving the use of vehicles. Of particular interest are quite a variety of crimes involving the use of vehicles as a means of getting away. For instance, what comes to mind are the old tragic instances such as the roadside murders of John Kagezi, Muhammad Chirumira, Andrew Felix Kawesi, Major Chigundu, and the General Katumba Wamala shootings, to mention but a few. Looking at the broader statistics, the Ministry of Works and Transport, which depends on records from Uganda Revenue Authority Registration and Licensing Department, states that as of 31st May 2023, there were 1,820,474 vehicles in the country. From the perspective of the Uganda Police Force and the Directorate of Prosecution, it would be helpful to monitor and address crime leading up to its prosecution basing on vehicle ownership. This is buttressed by one of the strategies for enhancing investigations, as mentioned in the annual police report of 2022. And this strategy is to the effect that the investigating personnel intend to apply more science in investigations, which involves the use of CCTV cameras, application of forensic science, telephone tracking equipment, and so on. The strategy does not directly mention the use of digital trackers on vehicle number plates, though it can be argued that this is where they would fall. So what are the concerns under data control? It begs the question as to where the digital number plates project falls. It is known to be part of the country's Intelligent Transport Monitoring System, ITMS, to increase efficiency in sectors of transport and security. The ITMS is said to be jointly implemented by the Ministry of Works and the Ministry of Security. In April 2023, the Ministry of Works and Transport issued a statement to the effect that it was taking over the registration of motor vehicles from the Uganda Revenue Authority. And this was to be aligned with government's implementation of the ITMS to be provided by a company known as Joint Stock Company Global Security, which is a Russian company. This company is to provide a centralized vehicle register where sensors are to be inbuilt into the registration plates. Under this project, every motor vehicle driver in the country will receive a new license plate incorporating technology, that enables law enforcement agencies to identify both the vehicle and its owner precisely and quickly. The new registration plates are projected to cost 714,000 shillings, up from the current cost of 150,000 shillings. According to the Ministry of Security, the high cost of the digital plates is justified because the Russian company running the project is investing all its money into the project and intends to recoup from its investments. The ITMS is projected to ensure that the data is accessible right away in case of an emergency, a car theft or an accident, which leads to quicker resolution of the incident through the identification of criminals or traffic violators. This will thus simplify the process of issuing traffic fines and also deter poor road behaviors and detection of crime suspects. However, the ITMS project has apparently left out the Ministry of Internal Affairs, under which the Uganda Police falls. So where are the projected strategies highlighted in the Uganda Police Force annual report to be impacted? According to media reports, the Ministry of Internal Affairs is of the view that the government contract with the Russian joint stock company, Global Security, is likely to conflict with an earlier contract signed with the Chinese company Huawei, which provides CCTV security cameras to the government. Besides the issue over a likely contractual breach, the ownership and use of personal data is also of concern. Data safety is about how agencies collect and share data. The use of the ITMS will be about monitoring and access to individuals' movements based on the data provided with regards to registration numbers for motor vehicles. In another sense, their ownership and constant location at all times. Privacy of data, therefore, comes to mind. Article 27 of the 1995 Constitution of Uganda provides for the right to privacy. However, this is not a non-derogable right. The government can exercise its prerogative to deprive any individual of his or her right to privacy, especially where matters of national security are involved. Objective 3, Roman numeral 1, of the National Objectives and Directive Principles of State Policy found in the Constitution provides for national unity and stability. It is to the effect that all organs of state and people of Uganda shall work towards the promotion of national security, peace, and stability. The emphasis here is on peace and stability. The government therefore gives priority to peace and stability, which are pillars of national security, when the right of privacy comes into play. Needless to state, however, the utilization of personal data in fronting national security, such as is being proposed through the ITMS, marginalizes a number of principles related to private data. With respect to the principles of data protection, the Data Protection and Privacy Act of 2019 provides under Section 3 to the effect that a data collector, data processor, or data controller, or any such person shall observe security safeguards in respect of the data. This means that such data is not to be misused or allowed to fall in the wrong hands. Bearing in mind that the data collector, processor, or controller, in the case of ITMS, involves a private party, which is the Russian firm, it is of concern as to how such data will be protected and utilized. It is therefore important to ensure that the global security company works closely with government agencies in the use of personal data drawn from the digital plates. Then there's of course the issue of consent in the collection of personal data. Section 7 of the Data Protection and Privacy Act is to the effect that personal data cannot be collected without consent of the data subject. However, under Section 7, subsection 2b, it may be necessary to collect or process such data for national security. Therefore, on matters of national security, we look at Section 18 of the Anti-Terrorism Act of 2002, which is to the effect that the Minister in charge of Internal Affairs may designate a security officer as an authorized officer, and then with Section 19 of the same Act, it empowers such an authorized officer to conduct surveillance of a person under the Act. Ideally, the Minister of Internal Affairs would therefore be the one to authorize an officer to undertake surveillance under the ITMS. However, it appears that ITMS is under the Ministry of Security, and the mandate of Internal Affairs has been sidelined, as mentioned earlier. The government should have clear channels of operation and owes a duty to its citizenry to point out how the ITMS will be operationalized and under whose docket it will fall. This is premised from Section 3 of the Data Protection and Privacy Act, which provides for accountability and transparency in data collection and utilization. In the absence of respect for the principles of data protection as stipulated under Section 3 of the Data Protection and Privacy Act, such surveillance and monitoring of personal data can be deemed unlawful and therefore a violation of not only Article 27 of the 1995 Constitution, but also Article 12 of the Universal Declaration of Human Rights and Article 17 of the International Covenant on Civil and Political Rights. Both international instruments, of which Uganda is a signatory, provide to the effect that no one shall be subjected to arbitrary or unlawful interference with their privacy. According to the UN Human Rights Committee General Comment number 16 on the right to respect of privacy, family, home, and correspondences, and protection of honor and reputation, under Article 17 of the Universal Declaration of Human Rights, it states that even interference provided for by law should be in accordance with the provisions, aims, and objectives of the covenant, and should be in any event reasonable in the particular circumstances. So mark the word that it should be reasonable in the particular circumstances. Under the same general comment number 16, paragraph 10 states that the gathering and holding of personal information on computers, data banks, and other devices, whether by public authorities or private individuals or bodies, must be regulated by law. Effective measures have to be taken by states to ensure that information concerning a person's private life does not reach the hands of persons who are not authorized by law to receive, process, and use it, and is never used for purposes incompatible with the covenant. The government of Uganda is therefore obligated by law to guarantee the integrity and confidentiality of data collected through ITMS. Such data falling in the wrong hands or being utilized for purposes outside of what it is meant for, which is curbing security in the country, would be a breach of this obligation and a breach of the international principles of the on the right of privacy. Section 21 of the Data Protection and Privacy Act provides for security measures relating to data processed by a data processor. It is envisaged that the Ministry of Works is the controller of data in this sense, since it is in charge of collecting and controlling information relating to vehicle registration. It is also envisaged that the Russian firm is to be the data processor under ITMS. It should be ensured that the contract entered into between the government of Uganda and the Russian firm abides by the provisions of Section 21 of the Data Protection and Privacy Act. Subsection 2 of this section is to the effect that such contract relating to the processing of personal data requires that the data processor establishes and maintains confidentiality and security measures which are necessary to protect the integrity of personal data. It is therefore not simply a matter of legislating over surveillance through the Data Protection and Privacy Act, so as for the government to show that it is fulfilling its obligations in respect to the right of privacy. In the famous US Supreme Court case of United States versus Jones, the key questions for court's determination were: 1, whether the warrantless use of a tracking device on the petitioner's vehicle to monitor its movements on public interest violated the Fourth Amendment, and 2, whether the government violated the respondent's Fourth Amendment rights by installing a GPS tracking device on his vehicle without a valid warrant and without his consent. This is a case where a gentleman called Enrico Jones, who was a suspected gang member and was into distributing drugs, cocaine and things of that nature, had a device placed on his car when he had parked somewhere, and the FBI used that tracking device to monitor his movements and then used that evidence against him in a later charge. So the court concluded that Jones had a reasonable expectation of privacy in his movements, and that the GPS tracking constituted as such under the Fourth Amendment. And the Fourth Amendment in the US Constitution protects people from unreasonable searches and seizures by the government. So by way of conclusion, we are all wary of the increase in insecurity in the country and the need for more effective means of curbing the crime rate. As such, government efforts should balance out various interests and be seen to be respectful of the individual's right of privacy, and the use of the ITMS should be approached cautiously, bearing in mind that a disregard to the principles of data privacy may do more harm than good. Thank you very much.
In a world where beauty knows no bounds, there exists a heaven of serenity, a symphony of nature's wonders, and a tapestry woven with the threads of culture and warmth. Welcome to the Jewel of Destinations, where dreams find their sanctuary. Here, among the laughter and melodies, you will find people whose hearts are as open as the azure skies above. Their smiles are the bridge to the world of stories, a world where every stranger is but a friend yet to be met.
Your friends and family,
Embraced by the arms of progress, this land is a testament of visionary leadership, where innovation harmoniously coexists with tradition. It's a symphony of modernity and heritage, painting a canvas that speaks of a thriving future. Beyond the horizon, where the suns meet the sky, lies a sanctuary for seekers of solace and adventurers alike. The beaches, adorned with the finest grains of gold, whisper tales of forgotten dreams and newfound passions. As the sun dips below the horizon, casting a palette of fairy hues, it reveals a land adorned with the nature's opulence, a sanctuary for explorers, where every step uncovers a treasure trove of wonders, as if the very earth holds secrets in its embrace. This is not merely a destination, but a symphony of experiences, a crescendo of moments that will linger in your heart forever. This is the ultimate holiday, where every heartbeat is a testament to the beauty of life.
Classes. Wow, well done. Shall we clap for ourselves? So, to start our day, ladies and gentlemen, shall we rise for the national anthems?
dedicate ourselves to rise together to defend our liberty and unity. All sons and daughters of Africa, flesh of the sun and flesh of the sky, let us make Africa a tree of life. Let us all unite and sing together to uphold the bonds that frame our destiny. Let us dedicate ourselves to fight together for lasting peace and justice on earth. All sons and daughters of Africa, flesh of the sun and flesh of the sky, let us make Africa the tree of life. Let us all unite and join together to give the best we have to Africa, the cradle of mankind, the font of culture, our pride and hope and break of dawn. All sons and daughters of Africa, flesh of the sun and flesh of the sky, let us make Africa the tree of life.
Care. We also had one on how to make sure that the limited funding is effective for the different interventions around privacy. And we also had very interesting discussions around surveillance and national security in Africa. Our day was crowned with a discussion on women in privacy, which gave us an opportunity to hear experiences for the women who are already working in the area of privacy. And it was a very, very interesting segment to crown the day. How many of us were still there when that took place? Okay, all right. So today is action-packed. It's a peak, and we have already finished master classes, education and IT, right? For those who were there this morning. And we expect panel discussions as well today that will be informed by the discussions you've had already in the master classes. We will have a panel discussion on ensuring privacy and data protection in mobile banking. We will have a panel discussion on safeguarding privacy in Africa, and as well as understanding the International Finance Corporation. We will have a panel discussion on preserving privacy in investigative journalism, and as well as a panel discussion on emerging technologies and citizens' rights in Africa. And we'll also have a mix of some presentations, paper presentations from key individuals as the day goes by. Ladies and gentlemen, to kick off our day, allow me to highlight the fact that apart from the Privacy Symposium Africa, Unwanted Witness has previously, as the primary convener, has previously organized the Unwanted Witness Moot Court competition. And this year we are privileged to organize the second, the only privacy moot court competition in Africa. This took place in September in Uganda, and it was targeting universities across the country. This saw the participation of 15 universities in the country. And at this juncture, I wish to share with you some of the highlights of this moot competition that was recently concluded in September. Ladies and gentlemen, the highlights.
The distinguished justices in absentia, the National Data Protection Authority Director, the Deputy Vice Chancellor, who is also our host, representatives from PILAC and the Makerere School of Law, the Motors, students, and distinguished guests. You're most welcome to be part of this day as history is being made.
Themselves. And the point I'm trying to make is why
can be held accountable for issues.
Sure that a non-disclosure agreement is signed. Now
the theme for the privacy moot competition today, which is balancing privacy rights and national security, navigating the impact of surveillance laws on individual freedoms, is thought-provoking and critical for the proper implementation of the Data Protection and Privacy Act of 2019.
The respondents relied on the 2010 decision of Uzun versus the Republic of Germany.
It was the position of the law, it was lawful that we did so, and it could be justifiable in a democratic society.
the GPS trackers in that much vehicles, rationally speaking, I withdraw that word.
My question is, are all the 1.5 million vehicles belonging to people suspected of terrorism?
When the government is interfering to privacy, it must be lawful, it must be pursue a legitimate aim, and it must be necessary.
Unwanted witness is commonly known for the right to privacy and data protection, but we do a whole host of so many things. Internet governance, digital inclusion, freedom of expression, but also the mood is just one of those components that we focus on when it comes to the right to privacy.
I want to thank Unwanted Witness for continuing with these privacy moot competitions. They are a good step in the right direction towards building capacity in understanding what privacy is, awareness on matters of privacy, how we can enforce our right to privacy, and also build capacity for the future privacy defenders and practitioners.
Ladies and gentlemen, Code 15 and Code 02, proceed to the finals. Thank you so much.
My lords, we pray that this honorable court grants and declares that the respondent, the acts of the respondent state were not in violation of the right to privacy, and the limitations taken by the respondent state are justified under the principle or the circumstances of national security, prevention of crime, and public safety.
Regulation 12(1) of the data protection and privacy regulation states that where the collection and processing of personal data possesses a high risk to the rights and freedoms of natural persons, the data collector, data processor, and data collector shall, prior to the collection, processing, and carrying out an assessment of the illicit collection, shall ensure that they do an assessment.
Chronology is important. The way you present your case. Present it in a way that you're starting from a good introduction, going into the meat of your arguments, and then conclusion is very important. And I'm happy, I like the way it was concluded.
Always identify what the test is. And I think the Deputy Attorney General was trying to do that. But you can be more precise around it.
Citation and use of authorities was fabulous for both teams, and I really want to thank you for that.
I hope that this moot has not only enhanced your knowledge in the area, but that it will trigger debate and information to guide policy makers, especially those from the government of Uganda.
We'll start with the best written submission applicant.
And the winner is Islamic University in Uganda.
Please appreciate them as they come.
Best Oralist Privacy Moot Competition 2023 goes to Martin Kitchen.
The first runners-up for the Privacy Moot Court Competition 2023 are Cavendish University.
Already evident. The overall champion for the Privacy
Und ich mit all den Sportlerinnen, mit der dicken, fetten Zugabe von Stand Up for the
Uganda. Ladies and gentlemen, as part of the awards, the winning duo was awarded an all-expense-paid trip to Mauritius, and I'm happy to say that they are here. Please join me in welcoming them to the stage as they come to share with us their story. You're most welcome.
Hello.
Still off.
Good morning. My name is Ida Gift Sambira. I'm a student of law at Islamic University in Uganda, Kampala campus. And this is my colleague, a fellow learning friend. I would like him to introduce himself before we proceed.
Okay, thank you, Ida Gift. My name is Chicho Martin, and I am from Islamic University in Uganda, the Kampala campus. And I'm part of the team that won the Unwanted Witness Moot Court competition of 2023. She was my teammate.
Once again, you're most welcome.
Thank you.
Thank you.
How do you feel being here this morning?
Very ecstatic. I mean, we just keep on being amazed and being so much informed by the information being shared around. We've had the opportunity of attending the master classes, the IT and privacy master class. Yesterday I attended the finance and the privacy master class. The panels here, everything is just amazing. Not to forget the beautiful country of Mauritius.
Ooh, all right. Okay, so can you share with us your initial reactions when you learned that you're the winners?
Initially, we didn't know that we would be the winners for Unwanted Witness. I remember during our time of preparation with Martin, it was during our first semester, and then we're in holidays, we would really joke about it and be like, how about if we ever made it and went to Mauritius? But it was something that we were just joking about. It wasn't something that maybe we had foreseen or anything of that sort. So when we arrived for the competitions, we really had what we keep calling them mediocre prayers. We kept telling God, help us go through the first preliminary rounds. Or when we went through the preliminary rounds, we're like, okay, God, help us at least make sure that we hit quarterfinals. And before we knew it, we're at finals. And if I can best describe it, it's more of having had a heart attack without really having the heart attack because because it was unbelievable. For both of us, this is one of our greatest wins because one, it's not a win just for, it's not just a win of, you're looking at just winning another moot competition, but it's building our career. It has made us have favor before our lecturers. Now we in school, we are given an audience to speak more just to our fellow students. So the win is more than just a win for us. It's a win for our university, for the young lawyers that are in our university. And yeah, I don't know if Martin has something to say about that.
Okay, the memories of that day when we won are still fresh in my head. And when they played the highlights, our coach, Miss Fatuma Nachirai, held my hand and she was like, oh, I'm feeling the shivers right now. It was really, really unexpected. I remember we were so frightened about the result, and I wrote her a note there when we were on the desk during the competitions waiting for the announcement. And we were like, well done, well done, well done. But we never expected that we would emerge winners because you cannot be so sure. You cannot be so sure because you're emerging amongst, you're versing the best of the very best from all law schools of Uganda. Yeah. You don't expect it to be an easy run.
True.
So, I mean, it caught us by surprise, but we were overjoyed and everyone was so overjoyed.
Good.
Yes.
Congratulations once again.
Thank you.
Thank you.
So, tell us, what motivated you to participate in the competition? What were your expectations?
Okay. First of all, personally, I've been looking for, the kind of the way our system is done in school is that we are given everything. We're given the civil laws, the criminal law from year 1 to year 4. And it's only at year 4 where you try and specialize in a certain field of law. However, in year 3, I happened to have asked my parents, what should I look at? Which field should I go to? And I didn't have, it was more of a vague, ambiguous kind of thing. And when Martin reached out to me earlier this year and said, there is unwanted witness and it's a privacy moot, it was a new field for me. And as an inquisitive person, I love to try out new things. So I'm like, okay, let's give it a shot. And you never know, at the end of the day, this might be a reason or something that makes my career build. Because we have so many civil lawyers, contract, we have so many criminal lawyers in our country, and there are very few experts in certain fields of work, yet there are real issues out there that really need the lawyers to work on them. So what motivated me was wanting to try out something new and maybe seeing that it could be a new thing that I can specialize in at the end of the day, and not just something that I can stop at and be like, okay, that door is closed, but it was more of an open door to grow. And yeah, maybe that's it, really.
Okay, personally, I'm fascinated by tech, and originally I wanted to pursue a career in legal tech, that line. And when I was presented by that opportunity by our coach, Ms. Fatuma Nachirai, she told us there's the unwanted witness privacy moot court competition going on. Would you like to take part? And I realized this is something in my direction that I would like to take on, but I didn't realize how vital privacy is in the first instance. Although I was fascinated by tech and all that and everything, but I didn't realize how vital privacy is, the right to privacy and other digital rights. Not until we happened to actually embark on this moot. And the more we kept on researching and attempting this problem question, the more it became reality that digital rights are really a thing. Privacy is something really very, very vital in the world. And the more we made research, it brought us closer to what is happening in the world, what is on ground. And I remember the hypothetical problem opened us to the fact that this is a hypothetical scenario, but it wasn't a hypothetical scenario in a sense. These were things that were happening in our country itself, because recently it was our government is trying to initiate the digital tracking number plates and all that. So the problem was around that, on balancing national security and privacy. So it was just fascinating, given that it even touches the real world. Was just a motivation for us. And like she has noted, these are units that we do not have in our legal curriculum, our study in law school. So it was just interesting to pursue something different from the conventional style. We had to go outside the lane and put on something, pursue something else. Yes, that was the motivation for me.
Very interesting. So I know earlier on you did touch a bit of on process, on your preparation. So we want to hear some more. Could you share a bit of how you prepared with your team? What were the strategies that you employed to make sure that you become the winning team?
Those were very, very good lessons and strategies that we use even now. So the beginning of we got the problem and became really serious about it towards end of semester exams. So what we did was we looked through the problem and ensured that we were familiar with the facts. So in a day, Martin and I would read the problem at least 2 or 3 times in a day without anything else, just reading it and making sure that we are familiar with every single aspect. We were looking out for those small nitty-gritties, those small things that could make us stand out. So after that, we got into our end of semester. I happened to have gotten a holiday to Kenya at the time we were actually doing memorials. So we were on a tight schedule to prepare for the memorials. And Martin is such a great team player in that he's like, okay, it's okay. I know you're going to be MIA for some days, but it's okay. I can try and handle. So we did research. We made sure that research was done and all those things. Now, when the memorials came to a close, we started practice. We were given an opportunity by our coach and coordinator, Council Fatuma, where she trusted us to bring in external help. And she in fact said, it's okay, you can bring in someone and to help you. So we got one of our fellow students. He had just graduated from another university, and he taught us the things that we didn't know. And yeah, it was a bit of an investment, being that he's also in the same age bracket. We trusted that what he did, because he had won certain moots, but he hadn't done the field of privacy, but he was actually good. So we would do intense online and physical preparations. I remember we would do late night calls, Google Meet calls, and our parents were, personally, my mother was like, it's okay, just do what you have to do, it is well. So we'd do late night calls. I think the earliest we slept every single day of preparation. This was on a daily basis. It wasn't like a one in a time thing. It was on a daily basis. So we'd do preparations every day from around 9 p.m. Ugandan time to around midnight. That was the earliest we slept. And if we're not good that day, would repeat until about 1 or 2. And he'll be like, okay, I think you've done good this round. Do it again. Then we see whether it's a good thing. This was every day, Monday, Tuesday, up to Sunday. I love my Sundays, but I really do love my Sundays. I don't get to school, but for Unwanted Witness, we were able to sacrifice our Sunday and Saturday, and we would be at school, we'd be at campus to access internet and to be able to practice, to be able to do the hard work, yeah. And even during the moot, we would actually sleep very late. We would sleep very late. We'd sleep about 2 hours every single day, and every single day of the moot competition, we were still preparing. So the preparations never ended until the final day. Yes.
So Martin, could you also highlight one particular moment where you experienced something challenging, and how did you and your team overcome it?
Okay, let me first highlight a little bit. She has said most, but our research involved intense research. We had to compare various regulations and legal frameworks from not only Uganda, but also other jurisdictions. What is being done in Nigeria? What is being done Africa continent-wise? What is being done in Europe? The GDPR, because it is like the gold standard of privacy laws and all that. So we had to really do intense research. And sometimes we were incapacitated by the fact that we have never been to those countries. So we had to look for people who are in those countries, talk to them, contact them. How is the situation over there? Because during our research, we got to discover that Kenya had actually initiated a similar digital number plate tracking program. But then we wanted to know the intricacies. What was this system? What kind of technology was it using? Were there any infringements? Were there any complaints by the people? We wanted to know that, but we couldn't get that. And we tried to reach out to some Kenyan friends, ask them, what's the situation down there? We've not had a lot of, activism around the digital number plates or any commotion. Are you guys okay with it? How is the situation on ground? But then we tried to get some friends here and there, though we didn't get like the full information, but the internet is there, so we got informed. Yeah, I think that I
remember one of our friends actually told us that Kenyans are okay with, I think, the digital issue because of taxes. So we're like, but Kenyans are the most radical people when it comes to certain things. Why are they quiet? And she's like, it's okay, I'm going to get you more information. So reaching out to so many friends out there, even on Twitter, would go and look at people, LinkedIn, so that they could help us actually know the different jurisdictions and things to do with data privacy. And it actually helped us beef our knowledge and perspective for the moot competition.
What advice would you give to future participants of the Unwanted Privacy Moot Court competition?
Pray. That's the first thing. Pray. I don't know how many people believe in God, but I believe that there is God and He leads the way. Because one, pray. Secondly, if you're a future participant, do not take it for granted that it's an easy thing, whether you have done it before. I would like to highlight that this was our first time mooting. on such standards and such platform. We had done one before, but we're still a little bit raw. But this was our first real big moot. So work hard. Future participants need to work really, really hard, because unwanted privacy moot court competition is not just a competition. It's more than a competition. It can define who you are 10 years, 20 years from now. It can direct your career. And of course, most of the people are going to be East Africa or the African state. Privacy is something that is growing. So let them take this seriously, let them work hard, make research, and also be a good team player. One of our advisors or people of wisdom told us that you're only as good as your teammate. So what we did was, before we became teammates, we were friends. So when you're not able to learn from your friend and be humble enough to learn from him or her, then you're not going to do a better thing. So be a team player, be humble, pray, and listen. We will really listen to our coach and coordinator. She should tell us certain things, and yeah, maybe we knew better. In privacy, we knew better, but she did know a lot of things, so we listened. Yeah.
Could you share a memorable moment that you found rewarding in your journey as you prepared for the competition and even during the competition?
Martin, would go first.
Okay, one of the most valuable things I gained in this competition is, first of all, the knowledge. And you'll notice that we are both in different groups right now, but our research projects, given that we are in our final years, are all focused on privacy. We got more interest in privacy, and that is something we really look up to, even up to now. Before and after, we got interested, and now we are still pushing. Another thing was the network. We met a lot of friends from various law schools that I wouldn't think would have been possible if we were just in our shells, in our university, and that's all. We met a lot of friends from various universities, not only the friends, our colleagues, but also the staff from Unwanted Witness. Just from that Unwanted Witness moots, our phones kept buzzing. We got opportunities, very many of them, and even up to now, just because of that single moment. And that's the highlight for me. I mean, that is all for me. I really find it telling.
Okay. Memorable for me would be during the competition. Before the competition was stretching, working harder than I usually do. I like multitasking, but this was a real multitasking. And being able to keep my word. When I told him we'd meet at 9, we would actually meet at 9. I would drop everything else to do that. Then during the competition was the friends we got, the networking. It was a privilege to not only meet experts, but also fellow students who knew a lot more than we had known. After the competition, the places we have been to, my research paper, our research paper that we are both going to do differently, in fact, is also a good memory. But getting on a plane, really, and coming to a beautiful country. It's my first time on a plane, so it's such an honor and a privilege to be in Mauritius. Being given an opportunity to sit next to people that have wells of knowledge. We have been able to interact with a few of them, and they have just given us a tip of the iceberg, but I'm excited to know what else the iceberg is actually holding. So it's going to be a lasting memory for me. Yeah.
Ladies and gentlemen, the duo. I want to open it up to the audience and just entertain 2 questions to the duo as we finalize our interaction. Do we have any questions for the duo? Okay. Going once, going to, okay. Yes.
Did your understanding of privacy and its value in our
digital rights ecosystem change as a result of the, yes, did your perception, your understanding of privacy and what it means change as a result of the experience?
The answer for me is, thank you so much for that question. The answer for me is yes, because right now, I hope that my understanding has actually changed, and I actually now want to do it. Like, I want to protect privacy in data. And one thing I can assure you, 2 years, 3 years, 5 years from now, I'll be a data privacy lawyer. So yeah, that
Okay, thank you. Thank you for the question. And like she has said before, privacy, yes, was there, but not something we would give attention. Digital rights were there, but not something we would give attention. But the moment we embarked on attempting the moat problem, which was concerning digital rights and privacy rights, it opened us to a different aspect that privacy rights are really a thing. Digital rights are really important. And that came in at a time when in our country they were initiating the digital number plate tracking system. Now, I'd come across that in the news, but I wasn't so much concerned about it. I saw it as something normal. I didn't know that it would maybe impact on someone's privacy and all that. But it came in at a time when we were actually going in for the moat, and then the digital number plate tracking system became serious, and then also the moat was also becoming serious. So it opened my eyes to something that, it is not really okay to monitor someone 24/7.
Yeah.
There must be limitations to what you're doing. You must not just give away, take someone's information just because you are the state and you have the power. Well, it opened us to very, very many things that we thought maybe are just mere. And that was enlightenment on the right to privacy and digital rights in whole.
Yes.
Yes.
So, do we have another question?
Yes, I have a question.
Yes.
Hi, congratulations on your win.
Thank you.
So this is a legal question. The area of privacy law is still developing. Based on your experience, what do you think will be recommended in terms of court procedures for specifically privacy cases? Because there are rules of evidence, there are rules of court procedures that apply to other kinds of cases, like criminal cases, family court cases, but for privacy, do you have any recommendations that the courts should consider specific rules of procedure for privacy law?
Martin could go first.
Okay, thank you very much for the question. Well, considering that approach, I think it would be more recommended to take a centric-based approach, a case-by-case approach, like they've tailored family laws and everything to specifically suit family laws. I certainly think that we should have a privacy law system, a legal framework, separate courts that handle privacy matters, because digital rights and privacy are something else different from these other conventional rights, although they are all recognized as rights, but we need to draw that distinction and not generalize them. So that means we need to adapt centric features of the system, centric systems. If there are courts, there should be a specific division in the court system that handles privacy matters with privacy experts sitting on the panels. I think that's the best approach that should be taken, tailoring everything to suit a situation of privacy, a related context.
Yeah, I think he has answered it quite well, but maybe just a little bit of...
In half a second.
Yes, in half a second. Just something that maybe we could recommend is an experience our side. From our point of view, our judicial system, most of the lawyers that are there or the judges do not actually know what data privacy is. So the first thing would be teaching them what it is so that they can be able to put in place the separation between data privacy and other laws and other procedures, court procedures. So one of the recommendations that would pray is sensitization and also allowing the young people to actually be part of some of these things, because Unwanted has provided an opportunity for young people to actually participate in privacy competitions. This means that the things that we're actually stating in there, the arguments that we are making, could be a way of building the procedures, could be a way of building separate rules and strengthening the legal framework that we are having that maybe is in place, or that one that they are thinking of developing. So yeah, thank you.
Thank you so much. It was nice having you here.
Thank you too.
Ladies and gentlemen, as we finalize this segment, our duo would like to surprise and appreciate someone very special and dear to the entire process and the entire unwanted witness family and partners. On stage to join us for this segment is their coach, and the dean. Is the dean around?
Yes.
Yes. So they'll be joining us. So the special person that they would want to appreciate is none other than the ED, the Executive Director of Unwanted Witness, Miss Dorothy Mukasa. Please, we welcome you to the podium to receive your token of thanks from the duo. Could we kindly give her a round of applause as she comes? Yes, keep it going. Thank you, thank you, thank you. Okay.
Would like to say thank you so much for the opportunity. Thank you for bringing us to Mauritius, and thank you for opening a new career for us as the duo, but as Islamic University in Uganda, Kampala campus.
Surprise!
Thank you.
Yeah, so, all right. So can we give them a round of applause as they go back to their seats? Thank you so much. Thank you, thank you, thank you. So ladies and gentlemen, this brings us to our next activity. We will be having a presentation from Mr. Okay, you ready? Yes, so we have our next presentation, and the presenter will be speaking about the future of privacy. So please, let's give him a round of applause as he comes to the podium. Thank you.
Okay, can you hear me? Perfect. Well, good morning, and congratulations again to the duo, which disappeared, but congratulations. Welcome for joining us at the guardian of the human experience with all of us. So it's great to see the future winning these kind of competitions. Should be a presentation coming up on the screen. In the meantime, I hope you're all awake. If not, I'll take care of that. Make sure you wake up, because believe me, after this presentation, your eyes will be wide open. So I'm Barum Rad, Chief Privacy Officer of the healthcare system of South of Switzerland. I'm here speaking to you about the future of privacy. The future of privacy, which you will see, is already the present. But first things first, we go quickly, just so you understand my background, which is important simply in this matter. Many of you, I think, are regulators or lawyers, come from the law background. What I found very interesting, I come originally from the IT background, okay, the data science engineering, technology, and then the privacy world fascinated me, so I went into law and I studied law. And as a lawyer, I've seen many lawyers during school also fascinated and sometimes in difficulty trying to understand how to apply the data protection law without truly understanding technology, right? That's not an easy task to do. So that background helped me a lot to do first the technology aspect of it and then go into the data protection. Now, before I start talking about the future of privacy, because of this fact, sometimes many of us don't know and don't understand exactly how technology works. I'm going to give you just a very quick introduction. And as a data protection officer of our healthcare system, we have 7,000 doctors and nurses. We start our awareness program, which you know is very important to do as data protection officer, with this. And I explain to you why. How many of you know what the dark web is, the dark net? Some of you know, right? Many of you maybe heard of it in some movies, in some TV shows, correct? What is it? Scary? Right? I'll tell you what it is. Just so you know, and maybe during coffee break and to your family, you can explain it in a very, very, very simple manner. So the internet that you use every day, which is huge, right? Enormous, is nothing but the 4% of the real internet that exists out there. That's called the surface web. is 4%. So imagine how huge is that 96%, called the deep web, and there's a small part of it which is the dark web. What's the deep web? You all use the deep web, okay? You all navigate in the deep web almost every day. Simple difference is this. When you are online on any website and you put a username and password, a login, you are in the deep web. That's the simple difference between the surface web and the deep web. Make sense? Okay, so if you're online, everything that's locked down is the deep web. That's the digital economy. Okay, that's billions and billions of US dollar transitioning in this scheme every day. So hospital, universities, any commerce that you have in any country, basically government are also in there, hospitals, we are in there, everything. Your work is in the deep web. Unfortunately, like every economy, the black market is this. The digital black market is referred to as the dark web or dark net sometimes. Now, previously in my, can you go back quickly? In my previous experience, I worked in the US. At the US government, we were tracking basically human trafficking children, especially here in Africa with the AFRICOM. And one of the things is we would explore and go and find these people being sold on the dark web. This is the dark web. Okay, you have pedophilia, you have human trafficking, you have trafficking of weapons, you have anything that you can possibly think being sold, including data. This is why you're here. Where do you think the data goes? Why do you even think you're protecting data? From what? From who? It's not just privacy or privacy being protected. Oh, I don't want to be surveilled with video surveillance 24/7. It's data being sold on the market. And we saw that, for example, health data from hospital has a value on the black market of about $250 to $1,000 US being sold, depending on how stigmatic it is. Remember the pandemic? Countries wanted to understand how many people were infected by COVID in one country or another country. Countries were being locked down from us traveling there because of a country being on the blacklist of our government, for example. That's the power of data, especially health data being sold in the market. Now that you understand this, I'll explain something to you. Imagine a future where your heartbeat unlocks your digital world, where your thoughts send text messages, where your body acts as an interface, connecting your life more than before. It's not science fiction. This is the Internet of Bodies, which is the evolution of the Internet of Things. It's an era where basically the line between our bodies and technology is blurred, challenging our most fundamental ideas of privacy and human rights. Are you ready for it? I'll introduce to you the Internet of Bodies and the privacy and the future of privacy. So basically, you can go ahead. What you will all know already is the IoT, right? Internet of Things, technology that today connects us everywhere, from your car, your phone, your TV. Here we have IoT everywhere. Right now, they're connected through IoT. It's the Internet of Things, right? You get in your car, you say, take me home. It will take you home. Now, the evolution of it is Internet of Bodies. What is it? You become a device. Now, the Internet of Bodies is separated in three sections, three stages. There's the external, okay, the body external around us, the body internal, and then the body melded. It's kind of scary just to think about it, but I'll explain it to you without panicking. So the body external, you're all used to it, okay? From Fitbit, Apple Watches, rings like this one, which is Oura Ring, for example, you connect, collect biometric data, everything that you put on your body, right? When you do sport, you have that heartbeat monitor, everything that is external to your body collects data about what? Your body. So it's collecting this data, then sending it to a cloud or whatever device you have. And then there's the second phase, which is body internal. In the US, at a hospital, we are testing already digital pills. You know what a digital pill is? Now you go to a doctor, he takes up blood sample or urine sample, and then it takes 3 days to process and send you the result. Now they send you home a little box with a digital pill. You swallow it. Within an hour, through connection in the digital world, the cloud and the EHR, which is the electronic health record of that hospital, receives your data, your parameter. No need to go and take blood samples. It's not necessary. Now your doctor will know within an hour your diagnosis or anything that he can prescribe. So that's the body internal. There are many different examples. And then you have the body melded. Sorry, before we get there, I'll finish. The body melded is basically people already have this, like an arm, for example, there is a bionic arm, a leg, or other part of the body that are actually made of devices. It sounds like science fiction, correct? It's really not. If you go next, in fact, I'll show you, we use it a lot in the healthcare system, huh? That's a lot being used, but we also monitor things like this one, the Mojo Vision. It's a contact lens. So it's part of my job as a chief privacy officer, which you will find surprising, is also monitoring IP, intellectual property, in technology. Why? Because that's the technology we then adopt. And that's the technology where we go and protect data on it. So this one is interesting. This is a contact lens that you put in your eyes. And by the way, the liquid in your eyes is also liquid that allows for doctor to capture how much insulin level you have for people with diabetes. So it's also considered a medical device. It's very complicated, has GPS, has augmented reality. You know, augmented reality is physical reality, and then you put in your eye and you have now augmented reality. It's interesting because it's also a device that can monitor your heartbeat and other parameters that you have. It will change the marketing world. As you can see in the slide, the last part here, you go around, let's say in New York or Mauritius, Port Louis, you look around and you say, oh, look, there's a sushi place, 3 stars, maybe not. Oh, look, I go to that other one, has a 5-star. That's really the concept of augmented reality. Next, you think this is an IP? No, it was introduced already this year with Vision Pro, coming into sales next year. What is Vision Pro? It's that intellectual property that you saw before integrated with Apple device, which is Vision Pro, will be sold next year on the market. You know what happened when Apple gets in the market, right? Disruption. Remember 2007, the first iPhone with the screen? Now kids are born and they do this with their finger already. That's the digital world. Imagine again when Apple comes into this market, disrupting it, introducing Vision Pro, which basically has augmented reality all around you. We see a disruption that can really happen even in hospital, but in the market. Imagine you won't buy monitors anymore. You won't buy a TV. Why? You have 25 TVs directly visually in your eyes. Why would you go buy an actual physical monitor? That's why it's important to monitor intellectual property. But then there are quite interesting questions about privacy. We studied this also in our hospital. A doctor comes to the operation room, put these glasses on, and sees the patient on the operation room. He sees all the vital detail, making sure that's the right patient, making sure they cut the right legs and not the left leg, right? The correct one. So it's very interesting. But then, of course, you have actual privacy questions. Now, if you go to the next one, because Apple is not the only one. Apple is the first one that will disrupt market. So if you go to the next slide, you will see something that was introduced a few weeks ago or a month ago, Meta, which you know Facebook, right? You know Ray-Ban partnership. They created the first glass with basically live reality connected with directly vibrating headphones. This is real. This is already in pre-order. You can buy it in pre-sale. You can already start pre-buying it. It will come into commerce soon, I think next year. In our hospital, which I hope in all your organization, we have a privacy policy. In our privacy policy, we're already introducing these devices. As a data protection officer, you try to understand what will happen when 1 or 7,000 of our employees buy these glasses. What happens when the patient comes and meets with the doctor and maybe is secretly recording the doctor doing a diagnostic? Then that could be maybe taken into litigation against the doctor if some medical error happened. You see, that's a future technology. We already integrated in articles within our privacy policy, teaching our employees how to behave, how to act around technology like this one. So it's a reality. It's not so much the future. It's interesting. But then you wonder, and you can go next, what the current legal framework is. I'll tell you right now, it's a Wild West. It's not easy to understand what applies to Internet of Body technology that is integrated within you, or once you become once body melded with technology. We try to explore it. For now, it's simply technology and privacy, and trying to run around these two standards for ISO standard, for example, that you know, ISO 27001, 002. We're kind of following that standard because there's no real legal framework. Government, as you've seen, here we are talking about a Data Protection Act that was introduced, but it's not yet this type of Data Protection Act. You see why it will need to evolve constantly, and law cannot change every year. Technology changes every month. You cannot keep up with it. So that's how it's important to understand how to stay behind it. In fact, if you go next, I'll give you some examples. You can click also one more time. So, I'll give you 3 cases. Apple's got into trouble some years ago with the device performance litigation. You know it, when they were accused of slowing down your iPhone through upgrade. So then you would buy a new iPhone, right? That's an interesting case, especially for data protection officers. What happened to our lawfulness and rights? No, sorry, go back again. And then look, how many of you remember Vice President Dick Cheney from the US back when George Bush was elected? What happened? In 2003, whenever he became vice president, in 2003, he had a pacemaker. Because he became vice president, they did an operation and they took the Wi-Fi off his pacemaker. Why? Because of terrorism issues. They were afraid that somebody would hack his pacemaker and turn it off. You see, already in 2003, that is 20 years ago, they were thinking of this integrated technology like pacemaker, which is not a new technology, but had already Wi-Fi, and that's the reality of the future of Internet of Bodies. You see, that's the vice president, one day will be any of us. And then there's the last case you see there. That's a real case that happened, especially think of us as hospitals. This happened in Germany around 2020. You all know what a ransomware is, right? It's basically a hacking intrusion into your system, and then they hold ransom your system, and they say you have to pay. Usually you pay hundreds of thousands of dollars or millions of dollars, depending how big your organization is. Think of what happened to this hospital. This hospital was hacked, put into ransomware. Doctors would come in the morning trying to log in. Nothing would happen. What happened is, at the same time, in the city center, a patient was put in an ambulance, really urgent, transferred to the ER room, the emergency room of this hospital. When they arrived in the ER room, the doctor said, you have to transfer the patient. We cannot do anything. We are blocked. We are under ransomware. The patient died going to the next hospital. That's one of the first cases where a ransomware, a hacking, we were talking yesterday about it also in some questions, a hacking really paralyzed the hospital, and the consequence was a human life. Usually when you hack a hospital, when you put a ransom a hospital, unfortunately, the consequence is a human life. Turn off the intensive care unit with people which live thanks to technology. Turn off the operating room when there is an operation going on. Turn off the emergency room, and you see the consequences. That's why it's extremely important, especially in healthcare, to apply the best due diligence and data protection that we can. But these are just some cases of what we are talking about in the future. This is nothing. Now, the Internet of Bodies introduces 3 main areas that are our focus for all of us to already think now: privacy, ethics, and security, and not just physical security, cyber security. Imagine if you have pieces of your body that are already digital, what happens if you turn them off? And that creates digital equity and digital dementia. You think this is science fiction? Go next. It's reality. What is digital dementia, for example? Imagine kids that are born today, they're already integrated with technology everywhere. They live with technology. You take this technology away, they literally have a deficiency in remembering and try. How many of you remember your mom's phone number, right? It used to be easier. One guy, good job, Tom. So it's not easy, right? We are so dependent from technology. So that is one part of digital dementia. It's a real search-proven aspect of IOB. In fact, it's not just technology impact your cognition, right? It's also, imagine in the future or near future where everything is technology, but the less fortunate or elderly people, you take away the technology, or you don't allow them to upgrade because you say it costs so much, then they become the dementia, digital dementia in our society. That's not mapped in Data Protection Act anywhere, and it has to be. It needs to be. So this is actually, it will create a digital divide for countries that are also less fortunate to have all this integration in technology. It's already happening now. You see it with IoT. IOB is the beginning of the frontier of digital divide. Now, you know, one of the biggest parts of IOB that is being talked about is really something that we are also exploring in our hospital. I'm telling you, we use a lot of this technology already, okay? It's not science fiction for us. You know, brain-computer interfaces, BCI. They have external one, you connect it as a helmet, relieve some of your information. So this is a technology that seems like science fiction that connect your brain. Go next. We use already in hospital this type of technology. But if you go to the next slide, you see, and you all have heard of Neuralink, right? Elon Musk, the founder, one of the founder of Tesla, they're creating this, has been already a company for a few years. It's one of the first real brain-computer interfaces in the third phase of IOB, body melded. They drill a little hole, they put this device with this filament, they close the hole, welcome to the future. This is the first type of real BCI. It will download and upload information. How is that different from your iPhone that download and upload information, right? You see how data protection officer have to start maybe one day identifying the body as an interface, as a device. Now you do it as a device, right? When you have a contract, you try to understand what device it is, who's the processor, where is the data stored. Now you are that same device. In fact, it's something that we're trying to understand what kind of impact will have in our society, not just from privacy standpoint, human rights, but also imagine from technology. Brain data is huge. It's billions and billions of data points collected at the second. Where are the data centers for all this? How can AI then help us process this data? Because it has to make sense somewhere, right? Now, if you go next, it's predicted, and it is one of the predictions they actually talk about, that in the near future, basically, most information will come from this basically personal data, from devices. If now you're thinking that all the devices that you have in your pocket, on your wrist and everything collect data, be ready for you transferring and transmitting millions and millions of data per second. You all know Web 1, remember it? For those of us that remember it, Web 2 is the current web. Be ready for Web 3, which is a decentralized type of blockchain internet. And this will shift and help ease in also IOB. If you go next, what we need to understand, because it's not an easy concept, I tried to introduce the internet body in this segment, just trying to give you a glimpse on what for many of us seems like the future. The reality is our present. The best key framework that we can introduce in a wild west of legal framework that doesn't really apply to internet body is embedding privacy in private sector. I would say privacy by design and by default should be the tagline for the IOB. If you want to integrate a chips in your hand, which is already coming in the future, you go subcutaneous right here. It's your passport, your vaccination, you open doors, whatever you want to do. How do you do it if you don't apply privacy by design and by default? This is the key, because you all know code is law, right? Law has to become the code. If you think of, as an engineer that develops software and apps, now we, as regulators, we develop laws and we introduce them, we apply them. Now the developer has to act as the regulator, coding the law directly into the devices that will go into our body or has to do with our data. In fact, next, it's not an easy concept to introduce. So we're creating this initiative, which is the Internet of Bodies Hub. The IOB Hub is basically a new concept. It's coming soon, where yesterday we were talking about the very importance of a network forum, so to have connection with all of us. There is a portal that will come. It's basically the future connecting multidisciplinary experts, so not just data protection officers, not just lawyers, but healthcare professionals, technology, engineering, doctors, government body, regulators, all on this platform, because networking and connection is the key to data protection. That's privacy by design. We connect all of us. In fact, IOB Hub Initiative is a website that's coming soon. It will be online very, very soon. If you go to the next slide. It helps to simply try to activate communication between all of us, integration to a dialogue, and we're also introducing IOB Labs, so we'll be testing with these technologies, the technology themselves, before they go on the market, before they can be sold. We want to be the guardians of the human experience, and you can all join this human experience protecting it. So as you have seen, it's a bit scary, but not really. I hope I did not introduce any anxiety in today, but you understand this is just the beginning. All we want you to do as a data protection officer or a privacy professional is not all about knowing just every article of your Data Protection Act. It's knowing and understanding in which direction we are going, because it's us humans that we need to protect. I thank you very much. That was my presentation. You see, it was quick and easy. I gave you like some 20 minutes. Now we have time, I say, for a few questions. Yeah? 2 questions. If anyone has questions, if anyone is panicking at the moment, you can raise your hand. I'll help you breathe. No? You have any question? It's all clear? Perfect. Well, if you have more question or anything that comes later, you can see me. I'll be around. Oh, there's one, actually. I think there could be also a question online, so just text them to me. Oh, here, and then there was one down there too. Yeah, go ahead.
Hello. Thank you very much, Mr. Mrad. My question comes in that given the fact that we are having rapid technological advancements here and there, emerging technologies, and now you've told us about the IOBs, what is the best way or what is the recommended way do you think laws can keep up with this fast growing pace of technologies? Because they still need to regulate these upcoming technologies.
Yeah.
Then the pace is just way over the roof.
Yeah.
What would be a recommendation? The laws, how would they easily adapt to this?
Yeah, discourse, collaboration, that's the key. The problem is that regulators, they meet in their offices, they try to regulate something that they don't exactly fully understand. Developer in Silicon Valley or anywhere in the world, they try to develop technology. Why aren't they talking together? Why isn't the conversation happening where they say, we want to introduce the digital passport, which would be integrated in your body directly? So we can basically, yeah, there will be a lot of issues of human rights and lawfulness and things, but why don't we talk about it? Security, national security, international security. So it should happen in a conversation. So as a lawyer, like as I do, I am every day talking to our IT department, to our chief information security officer. Then I go to conferences like this. I go to other places where the CES, I go and try to understand what's the future technology coming. And as I showed you, one of my specialty in law is also trying to understand and investigate intellectual property when it comes to technology. So I kind of try to see snippet of the future and anticipate them. So the best thing you can do is keep conversation going, not just between data protection officers or lawyer, expand your network. And that's what the IOB Hub is trying to do. Bring you closer to an IT guy, to anybody that is developing anything like that. Thank you for your question. Our champions. Go ahead. Sorry, yeah. If not, scream as loud as you can.
My question following the presentation is whether there's an AI element attached to the Internet of Bodies.
The AI?
Yes, because AI is very much in debate on how it's supposed to be regulated and how far we can allow it to go. Is this related to the Internet of Bodies?
Of course. That's a great question. You have seen everybody panicking right now, trying to run and create AI acts everywhere. You saw Europe introduce an AI act, right? AI is the discourse of today. Why didn't really talk about it so much? Because it's already happening. But AI is one of the tools in IOB. Because how do you read and make sense of billions of data being generated constantly, right? AI. How can you make sense one day of your brain-computer interface data? AI. So it's already part of the discussion, okay? AI is already being regulated in some country. It needs a lot more work. And the only thing as an engineer, I tell you, not just a lawyer, people are creating AI acts without understanding what AI is. People think that the AI that you have today, ChatGPT, is already general AI. No, it's just an index reading algorithm. It's not AI. You haven't seen AI yet, okay? So don't panic, because the AI that you see every day, I laugh sometimes at seeing people and regulators running around trying to regulate, oh, what's going to happen with AI? No, it's an index. It's a smarter Google. This is what's happening. The real AI is not here yet, but it's going to be here soon, and we're going to need it for this type of technology. Other questions? Yes? Yes?
Yeah, can I just?
Yeah.
Thank you. Zon, yes, thank you.
Yeah.
Yes, very passionately, you know, I would like to respond to some of this debate on regulation and technology. Definitely, like we all agree that regulation is always lagging behind, not only in privacy, but everywhere.
Everywhere.
That's a fact. But to say that, you know, regulation is ineffective, or regulation is not meeting the current demands of the market or technology, I think we should be very cautious about this in privacy, because in privacy laws, not only from a regulatory perspective, but from a privacy professional perspective, we have been putting some elements, some basic key elements in data protection laws, which are actually going in the direction of wherever technology is riding us to. What I mean to say is that, as you know, our laws are technology neutral. That is, today we have AI, tomorrow IOB, and perhaps afterwards, as you say, so many things happening. We don't know what AI is about, and we also agree to that. But what is also important is that when we make regulations, we have people who understand the situation, that is technology. And that's a gap that we are trying to bridge in the privacy community. We are having AI acts, especially in the EU, everywhere. But definitely, I think it's an effort that they are trying to make to be able to counteract the weaknesses of technology as it's happening day by day. So we should not, undermine the efforts that are being done currently. We should appreciate these efforts, but at the same time, definitely, we will need to update. And how do we update laws? Definitely in our context, for example, everywhere in the legal profession, we do that by, let's say, regulations. We have these quick, fast, laws that we make under the main mother legislation, and we actually come faster with these types of legislations regulating specific sectors and aspects like AI. So I think that it's all about communication between the regulator, the legal professionals, the privacy professionals, the technology world. It's about getting the right messages to the right people at the right time. And this is the point which is missing here. That is, it's not about law, it's not about technology, it's about the practice, what's happening on ground, and being able to take them into consideration, as you also pointed out, and to be able to meet them in the laws. But that is feasible. It's not something like, utopic, or like it's not happening, or it won't happen, or regulation is always failing. That's not the case. So thank you very much.
No, thank you, Fit. So data privacy is one of the most advanced regulation that there is. That's why I mentioned several times privacy by design. That's the one key that is so technology neutral that will apply anywhere you go. But then there's a lot of regulation that need to catch up with data privacy. Data privacy is one of the most advanced, but there's healthcare regulation, which is really falling behind. Internet of the body is healthcare regulation that's falling behind. So there's much more going on. It's great. What you mentioned, absolutely, it's one of the most advanced regulation today. Today, everybody's talking about GDPR, Data Protection Act. Yeah, it's one of regulation. Privacy by design, for me, is a key thing that you should always remember anywhere you go as a lawyer. That will help you catch up anywhere, 10 years from now, 5 years from now, with technology.
Okay.
Oh, you have one more? Yes, of course.
Yes, so as you're thinking of IOB Hub, how I'm thinking of the context of Africa, where we have very huge illiterate numbers, but these are people that are actually having access to data, or they're having access to share their data. How are you going to help I'll call them the low income earner, or the illiterate African, to understand that privacy by design is important to them, and that their data needs to be protected using IOB Hub? Like, how do you help them, break it down for them, to also help them get on board because yes, they are illiterate, but they have access to internet, they have access to some of these things, and they don't know that their data is not being protected, or they have a right to privacy.
Yeah, so what's already happened in Africa, which you've seen it, you hear today, is all these great data protection acts that are coming. That is already introducing the privacy by design that has to be there. The problem is that when you introduce technology that comes from other countries, so international data flow also is important, you have to adopt technology, but now with this act, you have the right to say, like you do the DPIA, Data Privacy Impact Assessment, you have the right to say, what I want for my citizen and my people is this type of technology that respect this parameter and this human right. You already have the base, the regulator already put in your hand. It's about you knowing that you have the negotiator hand on your side. Don't let technology immerse you and bring you to a leap of technology where they say now you have to adopt it. You have the right to know how to adopt it with this requirement, privacy by design. Thank you, everyone. That was it for me. And enjoy the rest of the conference.
Ladies and gentlemen, another round of applause for Mr. Madra. So, to continue our discussions from future privacy is our next panel discussion on ensuring privacy and data protection in mobile banking. Please put your hands together as we welcome our next moderator and as well as a panel that will be taking us through the discussions. You're welcome.
Choreography. She's going to cry.
Okay. It's on. Okay, now you can.
Yeah, they hear you.
Okay. Well, bear with me.
Well done. Okay, you've moved. Okay, that's fine.
None other than Mr. Brigadier Fujar, the illustrious executive director of the Mauritius Emerging Technologies Council. Today, he takes the reins, the distinguished moderator of the Ensuring Privacy and Data Protection in Mobile Banking Digital Payment Platforms, Addressing Challenges and Solutions in Africa's panel. Brace yourselves for a voyage of enlightenment and groundbreaking innovation at the 5th Privacy Symposium Africa. Ladies and gentlemen, please extend a warm welcome to the extraordinary Mr. Brigadier Fujar.
Okay. That's by far the best introduction I've ever had. Thank you for doing that. Wow, okay. So I am the Executive Director of the Mauritius Emerging Technologies Council. It's a brief introduction. I was based in Cape Town for the last 5 years, come from Gartner, and I took the role just to take the country forward around everything that's concerned with emerging technologies. So while hearing the previous person, I felt absolutely no pressure around the AI regulation, but this is something that we're definitely working on. Which brings me back to today. Today's panel discussion is on ensuring privacy and data protection in mobile banking, digital payment platforms, which is a critical issue in our digital age. With over 450 million mobile money accounts registered by the end of 2022, Africa is a global leader in mobile money services, which accounts for nearly half of the world's mobile money transaction. This kind of underscores the continent's leap in financial technology, where mobile banking is not just a convenience, but a lifeline for economic participation and inclusion. So today's session is not just timely, but essential, as Africa stands at the forefront of mobile banking innovation with a unique set of challenges and opportunities. So our objective in the next hour or so, I know we're running a little bit late, so we might need to speed up at some point, is to share knowledge that I call them now on board, Mr. Reza Mokun, with the Data Protection Commissioner. His role is pivotal in shaping the landscape of data protection in privacy in our digital age. Next, we have Henriette Esterhuizen, if I said that correctly, Senior Advisor and member of the Global Commission on Internet Governance. And we have Ms. Sheila Ajoda, the CEO of the Mauritius Institute of Directors. And we have two friends online, Advocate Durancho Mohale, who represents Standard South Africa as a data privacy lead, and Charles Okafumba, who is the CTO of Convexity from Nigeria. Please put your hands together for them also. Great. I'll take a seat, and then we can start. So I'll start with Ms. Sheila Ajoda. As a CEO of the MIOD, how do you view the responsibilities of boards and executives in ensuring robust privacy and data protection practices in financial technology companies?
Thank you, Rigesh. This is indeed an interesting question. And maybe I would like to put things into context first and take the Mauritian example. And I think not only the Mauritian example, I think worldwide it happens like this. So previously, when we had the Data Protection Act that was revised, especially Mauritius in 2017, well, data protection, data privacy was considered to be like a tick in the box exercise. But then as we move further, we had COVID, we had the evolution, Mauritius evolution in the digital landscape. And then we had Mauritius, for example, we were on the grey list, right? And then that's where we felt the need to further comply with whatever regulations we have. And then we had the AML-CFT that came in as well, and any other areas that we had to be looking into. So which means that now more and more, I must say that data privacy has been embedded in corporate ethos, especially in Mauritius right now. We can see the shift. The shift happened because of whatever events we had, COVID, etc., and the evolution in the digital landscape. Now coming back to the board responsibilities. Well, the boards are the guardians of corporate governance and ethical conduct. And this is as per the Companies Act in Mauritius, and I think Companies Act in other countries as well. We've got the duty of faith, the duty of care, acting in good faith, etc., etc. And furthermore, we've got the National Code of Corporate Governance, right, which I think in other countries as well, you've got Code of Corporate Governance, and that re-emphasizes the board responsibility with respect to their duty of care, etc. But then we had, there is another principle of code, which relates to risk management and internal control. And these principles mean that the boards are responsible for the total process of risk management and control. So what does this entail? That by not adhering to data privacy, so that would lead to a compliance risk. So which means it falls under the responsibility of the board. So that's one thing. But then I think your question comes to board and executives, is it?
Yes.
So the board cannot be everywhere. So by delegation, the board would, have executives, would delegate to executives, and that executives would have a prime role. They would need to lead by example. And how would they be doing that? They would have to implement policies and procedures. They would have to organize sessions of education, awareness, training on data privacy, for instance. And they would have to, for instance, have regular audits, right, to ensure that data privacy, policies and procedures are there. And then here in Mauritius, we've got the regulator here who are there, all right, they are there to conduct regular inspections as well. Whenever there are complaints, they are there to provide their support as well. So in terms of those responsibilities, clear-cut. But whatever I'm sharing with you with the code in Mauritius, it aligns with international benchmarks. And here I'm referring to the OECD principles of governance, where we have Principle 5, where it details the responsibilities of the board with respect to, those risks, those different areas. And one thing maybe I would like to highlight as well, that responsibility is becoming more and more crucial because the OECD principles was revised in September 2023. And one of the priority areas was digital innovation. And there are quite a number of recommendations following, that provision. So which means that board responsibility is becoming more and more important with respect to privacy, data privacy, and especially with the advent of technology, that we need to be, very careful and be on top of everything in terms of policies and procedures.
Thank you for sharing that. Probably a follow-up question around that is, one of the things that maybe was out there, even on the AI Act from EU, I'm diverting a little bit, but I think this is an interesting conversation, is how do you balance the risk-taking innovation with technology and at the same time ensuring that you're following in suit with all the privacy regulations? How do you balance that? Because at the same time, you want to keep on innovating, you want to keep on growing the companies, but then you also need to follow suit on the regulations and to ensure you're all in compliance. So how do you balance that at board level, at least?
I think that's a very important point you're raising, having the right balance, because today, in today's world, the way that there is evolution, risk evolution in the context, business context is moving, right? Definitely we need to innovate. There's no way out. How to balance about it? I think we need to have education, right? Be aware about it and aware of any ethical concerns that might come, with respect to that innovation, right? And those ethical concerns relate to data privacy, of course, and we've got security issues as well that we need to be aware. I think it should come from the top, right? It should be on the board agenda, definitely, and then cascade down to the executives and the other stakeholders as well.
Can I respond to that?
Absolutely.
As well? Thanks very much. I think it's a really key question, and I think the Internet of Bodies presentation touches on that as well. I think we have to rethink how we innovate. I think that the IT industry needs to operate perhaps a little bit more like the pharmaceutical industry, where we apply the precautionary principle, and I think if we look at, for example, the guiding principles on human rights from the United Nations, the obligation for innovators, for companies, to do human rights due diligence, I think that is accepted. But I think actually looking at risk assessments, doing research, analyzing the potential impact on humans, on social groups, on certain generations, certain age groups of innovation before it's released commercially, I think I know it changes completely how we operate in this industry, and I'm not saying it needs to be done in a hard regulatory manner, but I think it needs to become part of the practice, part of the accepted practice, and I think if you have a good balance and partnership between self-regulation and statutory regulation, I think we can actually shift that, where more products and services are first assessed for their potential impact on violation of human rights and other aspects of social and human well-being before it's released.
Thank you for that. That's quite interesting. And I remember one of the CEOs I met last year said, we are applying the brakes and accelerating at the same time. That's kind of a
exactly
kind of a thing.
Yeah.
Mr. Mukun, I'll come to you now. So with the rapid growth of mobile banking and digital payment platforms in Africa, what are the key privacy challenges that individuals and organizations face, and how can these challenges be effectively addressed?
Thank you. Thank you, Vrigesh. Hello?
Can you all hear Mr. Mukun?
Thank you.
Can we have someone just to check on the sound system? Isaac, Alan?
Maybe give you a roving mic. I'm fine.
It's here.
Okay, thank you for the question, Mr. Vigesh. So let me just highlight, mobile banking, it provides benefits to users, as you have mentioned. Millions of users across Africa, including Mauritius, are using mobile banking. So what happens, it drives financial inclusion as well as economic development across the continent. So what are the challenges from a privacy perspective? So there are large data collections and storage in mobile systems. They collect large amount of data about users and are stored maybe on third-party servers, which could be vulnerable to cyber attacks. There is also what we call data sharing with third parties access. They share data with marketing companies and data brokers. There's an increased risk of identity theft and other privacy violations. There is a lack of transparency and control.
Combating terrorism, war, or espionage. We have a secret panelist. Can he show himself? Is he hiding backstage? The argument presented by government security in this context is that by having a digital record of every vehicle number plate in the country, they will be able to easily track.
Is it one of your panelists?
Well, he should be here. I don't know.
When they happen, thus smoothing the investigation process and cornering the culprits behind the crime. As such, it is more like a big brother policy of knowing whose hand is in the cookie jar. As to whether this is justified in light of international domestic norms is the question. So by way of background, in February of 2023, the Uganda Police Force...
Sorry, is that Charles?
The highlight of the
Hello.
report is that crime...
Charles, can you hear me? He stopped talking now.
I can hear you, but it's not me.
Okay, let's get back to it. Mr. Merkin, please proceed. Whoever it was talking, you'll get your turn. Just wait.
So there is also a lack of transparency and control. So mobile banking and digital payment platform may not provide clear and transparent information about their data practices. There are also cybersecurity threats. Hackers can steal user data, access financial accounts, and even take control of mobile devices. And there may be also some regulatory gaps. For example, in ensuring that the mobile banking apps depends on the mobile phone, the number of the mobile phone. So there should be, and you have to ensure that the mobile phone is connected to that person, not to anybody else. This is where there maybe, in Mauritius, we have what we call a SIM card legislation. So, and also we need to have educating users about privacy risk. So these two will enhance the users as well as organizations to be able to implement proper mobile application apps. So I will just share a small case study with you about a recent bank mobile fraud. Just happened, maybe some of you know about it. It happens in a big bank. Some of the bank employees were involved in fake onboarding of bank customers into bank mobile applications. So the supervisory bank authorities has to intervene. There were deficiencies in the regulatory compliance related to know your customer norms. And what the supervisory bank has done, they have ordered the bank to stop his onboarding of customers, identify deficiencies, and strengthen the relevant process by the bank to the satisfaction of the authority. So that was a problem with the fraud on the mobile app application. So what is important? Our laws provide for security of processing, implement appropriate security and organization measures. It is there in the law. It is a responsibility on organizations. There is most important data impact assessment, they have to conduct this, analyze the risk, list the security issues as well as the privacy issues, maybe as a tick box, and then apply controls required to reduce the risk, and then see how the residual risk come. It is very important you see how your residual risk has come. And you should ensure that it has come to a low state. If at the beginning it is at a high state, you have to ensure that it comes at a low state. It is very important that banks carry out these data protection impact assessments, and they can share it with, report it to the authorities also. And there is, for the users, if we have to take they don't have too much power in those apps, but they have a high, what we call a high interest in these apps, because it provides them a lot of benefits. So what they can do as users, they need to be well informed of the issues involved while they are using those mobile apps, and report any doubtful practice to supervisory authorities so that actions can be taken in advance. But as we say, prevention is better than cure, so we don't allow the case to happen and then don't be wise after the event. So it's better we emphasize on prevention.
Thank you, Mr. Mokun. That was really great. I mean, the use case was a great example. Out of curiosity, it's not a local, is it local? Is it a local use case?
No, the bank is an international case, so I just take the example.
So we are doing good.
Very recently.
We are doing good. Thank you.
I did not name the bank, but it is available on the internet. You can search, you will find out.
Thank you. So Henriette, I'll come to you now. So you're based in Johannesburg, and you come with an extensive experience with that NGO we talked about earlier. How have you observed the landscape of privacy and data protection evolve in the context of mobile banking over the years in Africa, and what are the critical areas that require attention?
Thanks, Rigesh. I think, well, I would also just set a little bit of context. I think we sometimes quite loosely talk about mobile money and mobile payment systems and mobile banking, when they are in fact very different. And I think mobile banking and how mobile banking has evolved in Africa in many ways maybe has evolved because of competition coming from mobile money, but mobile money as it's provided by mobile network operators and mobile money agents is actually very different from mobile banking. And I think that presents one of the challenges. I think in the banking sector, there's a tradition of fiscal regulation. There's more of a tradition of data protection and of consumer protection, which you don't have, particularly not in the same way in the mobile money and mobile payment sector. And I think one of the evolutions, I think, that I think is, we've got to recognize the value add, and that more people have access to financial services, and particularly payment services. I don't think that equals digital financial inclusion. And I think that we tend to talk of financial inclusion in a very superficial way. When people are able to use their mobile phones, if they happen to have a smartphone, or if they have a feature phone and they have USSD services, and they're paying outrageous fees for being able to pay other people, that's not financial inclusion. It's one step towards financial inclusion. And financial inclusion involves saving, involves security, it involves the ability to get investment. There's a whole range of services that we don't factor into that. I think the challenges have been mentioned actually by my colleagues. I think that we particularly in the mobile money sector, the regulation is unclear, accountability is unclear. It's not always clear who's responsible for data protection. Is it the mobile operator? Is it the mobile money agent? Who holds what data? And I think users or consumers are not aware of what happens with their data. And also it doesn't come in the context of a relationship with a financial services provider, which I think still does characterize mobile banking to some extent, because you have a bank account and you have some relationship with that institution. institution. And then the mobile element is a different way of interacting with that institution. But for many people who use mobile payment services, it's not very unclear. It's very unclear who that customer relationship is with. So I think that is a. Do you want to ask a question?
Yeah, it's like I have 5 questions in the end, but I will ask only one. Don't worry. So you kind of describe like I would call a divide, like a gap.
Yeah.
Okay. What would be some concrete measures that you can think of that we could actually work on and implement to fill that gap?
Well, I mean, on the one hand, I would say at a very macro level, I think that, and this includes mobile banking as well, that the rights of poor consumers needs to be put front and center. We're dealing with a cybercrime context in Africa where most victims are actually small-scale crimes that targets mobile money or mobile banking customers. They are often not reimbursed. The losses are often so small that financial institutions are not particularly concerned with doing investigations. Law enforcement agencies are generally very poor in responding to that. So I think take the rights, the data rights, the privacy rights, but also just the rights to consumer protection and to be free from cybercrime of poor consumers very seriously. I would put that front and center. And then I think we have this emerging landscape of data protection in Africa, data protection legislation. We have more and more information regulators, data protection agencies. That's a positive element, but they need to connect with the consumer. There's no point in having data protection regulation when all it translates to is false consent or fake consent. And I think that's one of the things GDPR has given us. It's given us more impetus for data protection, but does it empower individuals? And are individuals who consent to their data being used aware? Are they really making an informed choice? So I think that would be the second thing that I would do, that due diligence, financial institutions, mobile operators, fill the regulatory gap. I think there's a regulatory gap when it comes to non-financial service providers providing payment services, and then put the user, the individual front and center, make sure that they are aware of how to protect themselves, what happens with their data. So more transparency as well, I think, is a key part of what needs to be done.
Sure. Can you hear? Okay.
Okay, so just to add, I think very good points that you've been mentioning, and maybe sharing some experience that I've seen in the market here is that, well, there are that level of people, definitely when they buy phones, for instance, right? It's the level of education where we have a problem. So whenever there is anything, so I think what I've seen is that instead of making them, suppose I'm purchasing a mobile phone, instead of making them buying just a phone and signing a contract, so the reading the contract there in front of the, because that person, maybe they might not master about consent, they might not master about their right, because the law it's there, right? The law it's there, it's just the way that we want to apply it would need to change and adapt to the context.
And then you need access to remedy as well. I think private sector companies in Africa get away with murder because we don't have strong consumer protection and users are not aware of their rights. So I think that due diligence, making sure that it's informed consent, putting those contracts into language rather than machine readable language, and then also making sure that there's remedy and recourse for people when they've not when their rights are being abused, losses that they incur as a result of.
Thank you, Arid. I mean, that's a very generic question, but by a show of hand, how many of you actually read your contract that you have from your local provider for your phones?
Yeah.
Probably no one. And I remember a very funny story. One of a software company, they included a clause in that long contract which said, if you come up with that contract and just hand it to me, I'll give you $10,000. And I think 5 million people in that country signed up, and only one person actually went and claimed that $10,000. That was a test to see who actually reads those contracts. But that's a very fair point. I think providers should ensure that those contracts are readable and more friendly for us to go through and understand what we're signing up for. Thank you for that. Charles, can you hear me?
Yes, I can hear you. Good.
How are you? How's Nigeria?
Nigeria is good. Nigeria is good. Thank you.
Well, sad you could not be with us today. Thank you for joining in. It's highly appreciated. So the question I had for you, Charles, is how can central bank digital currencies, CBDCs, contribute to improve financial inclusion in Africa while ensuring data privacy and security?
All right, thank you for that. First of all, I believe some of my panelists here has already explained what financial inclusion is all about, which just to give a little more context about it is the availability and accessibility of essential financial services to all segments of the population, okay? And this also covers savings, deposits, payments and transfer, credit loans, insurance, and all that. Now, for CBDC, which is the central bank digital currency, it's a novel idea which most central bankers are now looking at, especially here in Africa and my country, actually, Nigeria, because we have an in-era system, which is a CBDC. Now, for putting it in context with in line with financial inclusion. So one good thing about the CBDCs that we are seeing is it helps the government to kind of like reach the citizens easily, and also faster. Say, for example, let me give from my own country here. The government has a program, right? A poverty alleviation program. And they want to get in touch or make this money to reach those that really need it. So previously, the government would like to go through the banks that are already in the space, that is the banking partners, other banks that are available to get through to these beneficiaries. So they mandate the beneficiaries to have an account, or they come together with the banks and then they distribute these funds. But with a CBDC system, it is kind of like very easy for the government to get through to these individuals that really need this money or this intervention. So that is one aspect for the government itself. Now, for the private sector, this actually helps the private sector to innovate better. Okay, so this time around, you are not dealing with a virtual number money. Okay, that's let's say an app, a company or a bank creates an app, and the balance you are seeing there is just figures. But this time around, when you are dealing with the CBDC, you are actually dealing with the actual funds or the actual money of that country. But this time around, it's in a virtual form, which is traceable for the government and for everybody in that system. So for the private sector, it is easier for them to innovate easily, all right? Innovate easily and also send funds easily to the beneficiaries, or create program or projects, like create loans or make loans available or investment and all that. So with CBDC, it's kind of like easier for money to move around without having to maybe create a central point of failure. Like in my country, we have what we call NIPS, right? NIPS is a system whereby all the banking players, those that are in the banking system, they connect to it. So if I'm in one bank and you are in another bank and you want to send funds to me, you send funds, and then the funds go through that system before it hits my bank. No, but with a CBDC system, that intermediary is taken away, or that intermediary is taken out, right? So it is easier for me to kind of like receive money from you, and then I'll send money from you. So in terms of the speed, it's one thing. In terms of the cost as well, the cost of sending such funds to is it can be very minimal, because you don't have that intermediary there. And then the reliance on cash too. The reliance on cash is kind of like reduced. So those that are very familiar with the mobile apps or the mobile banking and all that can easily do their business or do their transactions and all that. But one challenge we have seen with a CBDC system is it's towing the same line with other financial products that are out there, in the sense that you have these beneficiaries that are maybe in the remote areas, okay? And most solutions we have seen there, they rely on internet, okay? Like if you have a mobile app or maybe a USSD, but if such service that a CBDC is relying on, or maybe other financial solutions are relying on, maybe internet or maybe the network providers like your GSM providers and all those stuff, if they are not optimal, if they are not working, so it defeats that aim, it defeats the purpose, okay? So what we are seeing in some innovative ways that the governments are actually coming up with is creating an offline solution, right? So that if you are spending a CBDC, it's like you are spending cash, okay? Because it gives you we've seen solution around NFC using an NFC card or an NFC bangle and all that to make payments. So that's, in a way, it's now mimicking the cash that the CBDC system is kind of like taking away. All right, so those in the remote areas can actually make use of it without feeling that, okay, since I don't have cash, that means I'm out of the financial system and all that. So they are just innovative ways to get through to them, and then hopefully it makes sense when we start counting the impacts and the numbers.
Thank you, Charles. I think you kind of also showcase the African creativity, because Africa always leapfrogs technology. And you brought in the challenge, but at the same time, you also talked about the solution for that. So I think we're eager to see how it evolves. I'll now move to Advocate Mohale. Can you hear me, Advocate?
I can hear you. Can you hear me, Vigresh?
So thank you for joining us from South Africa. I had a question for you around the successful approaches to addressing data protection, and very specific to the African financial services. So what would be the best practices that you could share works around that?
You know, Vigresh, it's quite difficult to get into such a discussion without speaking to challenges and risks that we are facing. But I will not go into what has already been discussed by the other panelists. But just as a start, data privacy is a risk, and it requires a multidisciplinary approach and cannot be implemented in isolation. So we first to find place for it in the enterprise risk management framework of the organization, both under information risk as well as compliance or regulatory risk. With data privacy, it can fit into, or not even it can, it actually does fit into all spheres of the organization. It is part, it's in the fiber of the organization. So some data privacy challenges that I have noted in my experience, specifically in Africa, and I think it can also apply elsewhere, but financial services in Africa are generally over-regulated while others are under-regulated. So you've got the banking sector with their online banking and internet banking, cell phone banking platforms, which will be regulated by the central bank and other financial services regulators. So you have a few regulators looking at one entity at a time. And for continentally, we've got the central banks that have been cooperating with each other for many years, unlike in other sectors. Then you have your insurance sector, which is not, it is also equally regulated in specifically, I can speak to certain countries and in South Africa, but there's not a collaboration and a cooperation for the continent. Then we had somebody speaking to, banking service, well, not banking services, but mobile money services, which you will find regulate, what is the English? You'll find that those ones are services, yes, provided by your telecommunications industry, and you'll have fintech. I think the central banks and the other regulators are starting to work together within South Africa, where I'm from, as well as continentally, to ensure that we're all aware of what is going on. The other risk challenge is that we have different levels of maturity when it comes to data privacy and protection in Africa. So you'll find that we have 35 countries of the 52 that have data protection laws in place. These vary from first to third generation laws. And also of the 52, we have 10 states that are having, I think it's about 3 states that have laws in draft. This makes it difficult for controllers operating in various countries to implement data protection programs and ensure that the data subjects with whom that they are dealing are well protected. It goes into adequacy of protection as well, and we can go on all day. But just to say that right now countries are facing pressure from others to ensure that they enact data protection laws. We've got the regional model laws, like the SADC model on data protection, which can be used by states to draft and model their own law, obviously with their own intricacies here and there. We have the Malabo Convention as well, which has been around for quite a few years, I think 9 to be exact, but it's only coming into force or basically came into force in June this year. And this is after they acquired the minimum 15 ratifications that are required. The third challenge is that we have a shortage of skills in the formal sector. IT skills within the continent are not properly utilized. And I think we're past the stage where we can be saying that data privacy is in infancy stage. As the first data protection law was passed in Cape Verde, I think it was as far back as 2011. The South African POPIA, which is the local data protection law, that was first publicly discussed as far back as 2005. Almost 20 years ago, if my math is correct, although it was only built in 2009 and promulgated 2013 and came into full force in 2021. So this is more than enough time for us as a continent to establish some data privacy and protection formal education programs at different levels. People looking to get into the study or the field now, either it's a coincidence, they found themselves in the area, they need to study something else that is data privacy related. I know that there's a master's degree in a few universities that have data privacy as a module, but we don't have anything in Africa that gives us detailed data protection courses. Yes, we do have one at University of Pretoria, we have one at UCT, we have a data protection course on the Kenyan Data Protection Act at Strathmore. And these are basically, they don't provide us with the level of certification like the EU's IAPP certification provides. A fourth challenge I picked up is that principles-based legislation as opposed to rules-based legislation makes it a bit difficult for data controllers to implement. For compliance officers, implementing principles-based, risk-based, or even outcomes-based programs is not a new thing. But in many organizations, data privacy doesn't sit in compliance. And I'm not saying it should, but as I mentioned earlier, that data privacy is a risk that needs a multidisciplinary approach to remedy. So for me, the best approach to addressing these challenges in the financial sector, and specifically for multinationals, is to implement a data privacy program that is based on principles of data privacy as opposed to law. The law will, of course, influence the program, but it creates its own, what can I say, law within the organization, within the sectors within which it conducts business. So quickly to get into the approach, without going into much detail has been provided already by the various panelists. So as I mentioned earlier, multidisciplinary, we need to have functions from the legal, from risk, compliance, ethics, IT, business operations in your strategy. And then the first place to start would have to conduct your risk assessment. If you don't know what your risk is, you won't know what controls to put into place, what program should look like. So in here, we basically identify all the processing activities that take place within the organization. Basically, your what, when, where, why, and your how. You look at your regulatory universe. Data privacy cannot be looked in isolation of other laws. In South Africa, there are many other laws that regulate processing of personal information, personal data, and we need to ensure that all of these are covered and similarities and similar or same controls are identified and made use of. We need to look at regulatory requirements, registration of entity or persons, and also registration of certain processing activities. In South Africa, we need to apply for authorization to process high-risk processing, whilst in other countries, a DPIA is required to be conducted to ensure that the risk is properly identified and mitigated.
Thank you very much, Advocate Mohale. That was brilliant. Apologies are being signaled from left, right to just proceed with the panel. We're a little bit late in the program today, but that was brilliant. Thank you for all those insights. What I'll pick up is the need to always be communicating among stakeholders. I think that's the first thing that's been mentioned a couple of times. Ladies and gentlemen, please clap of applause and for our panelists. And we are now ready for questions. Any questions? There's one gentleman at the back. Can we get him a mic, please, guys? Anyone? Unless if you want to stand up and shout, that's up to you.
Yeah.
We need a mic.
The room has wonderful acoustics, actually.
Yeah. A mic. There's no one with a mic around, please.
There's a mic here.
Yeah. Okay, I'll come to you. I don't know if that works. Thank you, my friend.
Teamwork.
Teamwork.
Thank you very much for your insightful discussions. My question is very simple. It's about, actually, you've been discussing about, you talked about the loopholes, regulatory frameworks about mobile banking and even mobile money. So I would like to know the common loophole that you can identify or you've identified across the continent. Thank you very much.
The common?
Of course, in relation to data protection.
Share loopholes or any kind of weak spot. I'm curious to know why this question though. Are you trying to find a loophole in the system? Mr. Mokun?
So we have to learn from experiences what happens and see where the loopholes are and then come up with appropriate legislation. For example, I will mention, in the mobile apps, you depend on the mobile phone of the users. So you have to ensure that the mobile phone is attached to the users, not a fake user. So we have to ensure this, maybe by passing legislation to ensure this is enforced. Because we have seen there are millions of users using mobile apps for payments in Africa. So this is a very important aspect of ensuring the identity of the mobile phone user while using his mobile app. So there can be legislation or regulations coming on this aspect.
Can I just give a slightly different view? I think SIM card registration has a very mixed reputation in Africa. It's in South Africa, for example, getting pre-registered SIM on any street corner is possible. In Nigeria, SIM card registration hasn't really been successful in combating cybercrime. So identity verification is very important, but just using the phone and the SIM card and over-relying on that in a country like South Africa as well, where there's a lot of crime and a lot of theft of mobile phones. In fact, that exposes the consumer to more risk. So I would say that looking at identity verification is absolutely important, but it should be done in a context specific way. And I mean, yeah, we probably have to do closing remarks. I think one thing that do you want to add to that?
Yeah.
Me too, please.
Since everybody was at it.
Is that Charles?
Yes, yes,
Oh,
also.
okay.
That's Charles, actually.
Would you like to contribute to something, or were you not just on mute when you were supposed
yes,
to be?
No, I'm actually watching. So I wanted to add to that, right? So Nigeria, right? We started with SIM registration, but that didn't really work. The country presently have an identity system, right, where everybody's meant to be registered, more of like you need to have your personal identity number. Mm-hmm. And that, in a way, is what the country or the government is now using for tying into the CBDC system, right? But there are different levels because you need to have some of those people that are in the remote area that don't have this identity system, but they have easy access to SIM registration, and the SIM registration has some of the identity. So what the country did was limit their access to how much they can get or how much they can receive versus somebody that has a full identity. So like one of the panelists noted, yes, the system is porous. SIM registration or using SIM registration as an identity system is very porous, right? It's been hacked, some are putting in fake identity, but having a real identity system in place by the government will really, really go a long way. And also, okay, maybe the closing remark I will add that regarding blockchain security and the privacy. It can be, the blockchain just provides more of like a pseudo identity system, right? It's not really, really private. And that's why the bad actors are kind of like running away, because it's easier for you to catch a criminal that commits crime using a blockchain system for transaction than somebody outside that is using a cash or fiat.
Thank you very much, Charles. We can't take any more questions. We're running a little bit late on the program. So again, thank you very much for listening, and huge round of applause for our panelists. Thank you, Charles. Thank you, Advocate Moale online. Thank you for making time and joining us today. Thank you.
Thank you.
Thank you all. Enjoy the conference. Bye.
Thank you.
Thank you.
Bye.
a world where beauty knows no bounds, there exists a haven of serenity, a symphony of nature's wonders, and a tapestry woven with the threads of culture and warmth. Welcome to the Jewel of Destinations, where dreams find their sanctuary. Here, among the laughter and melodies, you will find people whose hearts are as open as the azure skies above. Their smiles are the bridge to the world of stories, a world where every stranger is but a friend yet to be met. Embraced by the arms of progress, this land is a testament of visionary leadership, where innovation harmoniously coexists with tradition. It's a symphony of modernity and heritage, painting a canvas that speaks of a thriving future. Beyond the horizon, where the suns meet the sky, lies a sanctuary for seekers of solace and adventurers alike. The beaches, adorned with the finest grains of gold, whisper tales of forgotten dreams and newfound passions. As the sun dips below the horizon, casting a palette of fiery hues, it reveals a land adorned with the nature's opulence, a sanctuary for explorers, where every step uncovers a treasure trove of wonders, as if the very earth holds secrets in its embrace. This is not merely a destination, but a symphony of experiences, a crescendo of moments that will linger in your heart forever. This is the ultimate holiday, where every heartbeat is a testament to the beauty of life.
The distinguished justices in absentia, the National Data Protection Authority, Director, the Deputy Vice Chancellor, who is also our host, representatives from PILAC and the Makerere School of Law, the Mutas, students, and distinguished guests. You're most welcome to be part of this day as history is being made.
Themselves. And the point I'm trying to make is why
can be held accountable for this.
sure that a non-disclosure agreement is signed. Now
The theme for the privacy moot competition today, which is balancing privacy rights and national security, navigating the impact of surveillance laws on individual freedoms, is thought-provoking and critical for the proper implementation of the Data Protection and Privacy Act of 2019.
The respondents relied on the 2010 decision of Uzun versus the Republic of Germany. It was the position of the law, it was lawful that we did so, and it could be justifiable in a democratic society.
the GPS trackers in that much vehicles, rationally speaking, I withdraw that word.
My question is, are all the 1.5 million vehicles belonging to people suspected of terrorism?
When the government is interfering to privacy, it must be lawful, it must be pursue a legitimate aim, and it must be necessary.
Unwanted witness is commonly known for the right to privacy and data protection, but we do a whole host of so many things. Internet governance, digital inclusion, freedom of expression, but also the mood is just one of those components that we focus on when it comes to the right to privacy.
I want to thank Unwanted Witness for continuing with these privacy moot competitions. They are a good step in the right direction towards building capacity in understanding what privacy is, awareness on matters of privacy, how we can enforce our right to privacy, and
Ladies and gentlemen, we have our next panel, introducing our next panel discussions just before we break for lunch, and that is on safeguarding privacy in Africa. Quickly, I would like to invite our moderator and the panel members. Ladies and gentlemen. Is your mic on? Your mic. Is my microphone working? It's you. Okay. Okay, it's on.
Is this working? Are you able to hear me? Perfect. All right. Thank you and welcome to this panel.
Just wait. I'm going to wire him, don't worry. Okay. Yes.
Yeah, sorry.
The words, I'm Gaia. I work on digital rights, but my focus is corporate accountability of tech companies. I work with the Business and Human Rights Resource Center, where I lead the work on tech and human rights and what we expect companies to do. We already started the discussion this morning about concerns and anxieties we have on artificial intelligence. What we certainly do know is that artificial intelligence is not new. And one of the anchors in a discussion recently said, there's really nothing artificial or intelligent about this, but we'll probably find out more about that as we dig into this session. What certainly stands out about AI is that it has transformed lives, it has transformed sectors, it has transformed our lives economically and socially. In this truly multi-stakeholder session, what we will do is try to address anxieties around the impact AI is having on our privacy and privacy of vulnerable groups and different communities, and try to figure out what is the right response, what are the right concerns to have, and how do we go about addressing this. To help us unpack this, let me first invite Malaika Hinaye Mahmood Khan, who's with the Faculty of Information, Communication and Digital Technologies from the University of Mauritius. Joining us also on stage is Jean-Michel Felix, who's the CEO of MCB Consulting. We will also be joined by distinguished panelists online, starting with Mark Richard Gaffley, who is the director of Africa think tank AI from South Africa. We also have Professor Jerry John Koponyo, who's the PI and Scientific Director at Responsible AI Lab. We have with us Essa Muhammad Ali, who's the Director of Tanzania AI Lab. And what we will do is try and dig into these questions as we start this process. Let me first go to, we had a plan of first digging into the broader questions around AI, but I'm going to go to Professor Jerry John Coponio. Could you please let me know if he's online, if he's able to hear us?
I can hear you.
Jerry, are you able to hear me fine?
Yeah, I can
Sorry.
hear you. I hope you can hear me too.
Yes, yes. Jerry, why don't I get started with you and drawing on your experience with the Responsible AI Lab and sort of pulling away from the broader conceptual questions, right? Could you possibly talk to us about how AI can play a meaningful role in sustainable engineering and sustainable practices around engineering solutions, right? Especially ethical frameworks around that. And drawing on your experience, could you also talk about personalizing AI a bit more and how AI can possibly help us respond to real life, real world challenges?
Okay. Thank you. Thank you so much. It is an honor to be on this panel with my distinguished colleagues. I would like to deal with the issue of, first and foremost, when we talk about ethical AI as it relates to engineering, what exactly are we looking at? So ethical AI is responsible AI. And responsible AI translates to human-centered AI. AI paying particular attention to the impact that it has on the human person. Now, I deal with the cycle as far as the development of the AI solution is concerned. In developing the AI solution, there are 4 key things that we need to particularly look at. We have to consider the envisioning stage. We have to consider the data based on which models are being trained. We have to look at the modeling parts, and then we have to look at the deployment stage. And so when we look at ethical AI in the context of engineering, we need to also look at the fact that in all engineering solutions, we can replicate these 4 key aspects of the development cycle, i.e., the envisioning stage where we think about the engineering idea or the solution to the problem, the data side where we are looking at what data we are using to train our models, the modeling part, and then the deployment stage. Now, in terms of ethical AI, it is important that at every one of these stages, ethical principles like fairness, like transparency, like safety, privacy, security, and ensuring that we're even environmentally friendly with the deployment of our solution are all particularly considered as far as the development cycle is concerned. And so basically what I'm saying is that whatever solution that we are developing, it is ethical to the extent that it is having a positive impact as far as humanity is concerned. And so in every solution, it is always important that we look at how does it rub off the people? What kind of impact is it making as far as the people are concerned? Now, let me now come down home to practical applications as far as the work that we are doing in the Responsible AI Lab is concerned. What I can say is that we recognize that AI is the new chip on the block. And it is important that we recognize the transformative impact that AI can have on key sectors as far as economy is concerned. We have tried to apply AI in the area of agriculture. We have applied AI to the area of health. We are looking at AI interventions in energy. And most importantly, we are even looking at how AI can influence the people who are differently abled in the name of using AI for assistive devices for people who are differently able. Now, the question that we then have to answer is, how then do we work in ethical principles as far as the development of these solutions are concerned? What we have done at the Responsible AI Lab is to develop a framework through which we are able to quantitatively measure how responsible an AI solution is. And so, for instance, in interventions that we are developing, like the application of AI to detection of plant diseases, or the application of AI to the determination of rare diseases among children, we recognize that there are huge amounts of data that we need to gather as far as training our models are concerned. And it is crucial that we apply ethical principles to the amount of this data. And that is the more reason why this particular conference comes in handy as far as application of ethical principles are concerned. We need to seek the consent of the people from whom we are gathering the data from. And where we have obtained consent for the use of the data for one application, it is important that we do not extend it beyond what consent has been given, so that we respect the rights and the privacies of people from whom the data is being gathered. And so what we have done is to develop a framework through which every solution that we are developing, we are able to measure how responsible this particular solution is. And so the strategy is, in engineering, development of engineering solutions, we need to apply these solutions within the lens of frameworks similar to what we have developed, so that on that basis, we are able to make a determination whether we are being responsible in the deployment of this solution or not. And so two things have I tried to talk about. When we talk of ethical AI, how does it apply to engineering? And how are we able to apply frameworks in practical deployments? My conclusion is that it is always important that in every deployment that we are coming up with, we look at how it impacts on society, and how we are able to measure that is to use frameworks that exist as a lens through which we make a determination whether the solution we are developing is a good one or not. Thank you.
Thank you, Professor Jerry John. Those are really critical and pertinent questions, and I hope we'll keep on figuring out the responses to how can we make this more human-centric, how do we make it more responsible. Perhaps can I call on Mark Richard Gaffley? Are you able to hear us, Mark?
Can you confirm over online speaker, please? Online speaker.
No? Yes, Mark, are you able to? Is the audio working okay?
Is Mark online? And Mark? Okay.
No? Okay, let's try and get Mark back online. But perhaps Essa, are you able to work with the audio?
Yes, I can hear you. Can you hear me?
Yes. Yes, thank you, Essa Mohammed Ali. I was wondering if maybe you could help walk us through drawing on your experience with the Nigerian national AI policy, what you see as the critical components and objectives of a comprehensive AI policy, and what you see as possible directions for the evolution of AI policy in Africa.
Sure, thank you. So first, in reference to the Nigeria AI policy, for context, the policy is not yet released to public. We were part of the volunteer experts group that worked on contributing to the policy, and one of the areas where our team was part of was the general and ethics side of the conversation, looking at responsible AI. And of course, when you look at a policy that is looking at being able to enable an artificial intelligence environment, but at the same time safeguard the privacy and protection of the citizens, citizens that seeks to strike a delicate balance, because on one side, as technologists, we will be like, give us whatever data we can get to work with, because current artificial intelligence methods are heavily data reliant. What that does imply, though, is that there might come a future where we wouldn't be as data-centric. There are potential methods we can explore that aren't as heavily reliant on significant historical data and could enable other approaches as well. But the current methodologies that have shown the best traction and the best results are ones that are heavily data reliant. So we start to see this attempt at a balance of being able to enable the technologies to build their solutions by finding out what are elements of data that can be made available and what are elements of a citizen or an individual's information that must be safeguarded. And of course, this changes from solution to solution, because in some areas such as healthcare, having specific demographic information might prove to be highly necessary in certain diagnostic processes, for example. And when it comes to Africa's direction in policy, we're seeing different approaches. Some are being inspired by the European approach, which is looking at risks and mitigation. Others are looking more across how can we create a stronger enabling environment for these technologies. And what we see across Africa is that a lot of the development is happening in communities compared to Western or Northern approaches that are either being led by government initiatives or by corporate development. Instead, in Africa, we are seeing community-driven approach. And what we mean by this is individuals who are either starting small companies or projects that are working on building AI-driven solutions. And the risk this has is, as an individual who hasn't necessarily gone through the training or thought process that comes around building an ethical solution, and a lot of times has limited awareness or understanding of current policy or guidelines in place, they can build solutions or systems that pose significant risks, but also benefits. And because of that, a lot of the work we're exploring is building awareness around existing policy and frameworks. And what we see is that something like an AI policy framework doesn't necessarily have to be contingent on just the policy itself, because it's built up on other policies as well. For example, data privacy and protection contribute significant towards an AI policy. Intellectual property policy is very important as well. So we can move forward without necessarily having a direct AI policy, but we need to make sure that the other policies that could be considered foundational or pillars to an AI policy, there is awareness and understanding of what they consider how they approach things. An example in Tanzania is we recently launched our revised data protection and privacy policy. And one of the areas it considers is processing of data, where certain data points that would be considered protected have to be computed within national borders. But then this does provide limitations in terms of does the country have significant enough compute power to process significant data such as images or large language models, and then what limitations does that pose? So we are finding that it's proving to be an interesting journey of finding what is that balance that gives the best opportunity, but still safeguards the citizens' right to their privacy and protection.
Thank you, Essa. Perhaps what we could do is look at some more examples around what are the practical challenges, and then try to bring it back and align it with points you made and in the earlier panels people made around policy, and possibly we'll have more conversations around what kind of policies that Africa needs to move forward in dealing with the rights implications of AI. Dr. Malek, can I come to you for a minute and try and explore the challenges in the actual implementation and challenges that IT players in Africa, for instance, face when it comes to obtaining and managing user consent in AI-driven applications, especially when it comes to informed consent. What have you seen as possible solutions to managing that consent and making sure you obtain that consent? And what do you see as possible measures that organizations in Africa can take to take the existing policies we have and align it with challenges and possible solutions that AI is trying to provide us?
Yes, okay. First of all, thank you, Gaia. Thank you for inviting me to this symposium. Since in the morning we are all talking about how AI is transforming the world, how we are developing applications. So one thing is that it is very important, we cannot deny that it is very important to have AI applications, right? So to develop these robust AI applications, we need data. So to build a very good AI model, it is very important to have good data sets, to have data. So on the other hand, to have this data, we need to have consents of users, right? So if we don't have these data, we won't be able to build good data set. Now, we have a lot of challenges, like you were mentioning, in terms of user consent. First of all, there is, what I have seen is that there is a lack of awareness, right? People, they are not even aware of data privacy and consent issues related to these AI applications, right? So these become very challenging in order to, we have to tailor these AI consent. We have issues with regard to this. And on the other hand, Africa is a diverse continent with various language, with various cultures and digital literacy, right? So there is a need, to tailor these consent mechanism to reach, people, and this is really very challenging. On the other side, like some other panelists, they are mentioning, we are developing AI applications for the bank, for the healthcare sector, for different domains, right? And in these domains, we have very complex technical language, right? In order to develop these concepts, when you seek for consent of the user, you have to put it like in a clear language. You have to have clarity in the concept. So one thing that I have noticed is that it is at times very difficult to put it. This is a big challenge to have this concept in a clear language so that you can reach people. This is really a big challenge. We also have the issue, people are saying, okay, we are developing AI application, and many people, they see this AI application as black box, we just see, okay, AI application is a magic, we just input things in that model and then you get an output. So among a large population, we have, this mistrust. People do not trust this AI application. They just see, okay, there is magic inside. I don't know what people is doing with my data, things like that. So this is really a big challenge that people face, developers face, researchers faced while developing these AI applications. On the other side, another thing, people do not just develop like an application for only a region. It can be like, across the region, across Africa, that we are developing application. And the thing is that the privacy and consent, they can vary across African countries. And this make it, very challenging for players to navigate and comply with the different set of rules that are being in place, right? So we have these challenges. Now, how can we address these challenges? One very important thing is education. We have to promote user awareness about data privacy, about AI application, and this should be like through public awareness. people may say that, there are different information available on website, from regulatory bodies, etc. But what I think is that this kind of information should be presented in a user-friendly manner. You have to reach this general public, because if you don't reach these people in a user-friendly manner, we have all sorts of information, privacy is everywhere, we have all kind of data being available, but if it is not in a friendly way, if it is not in a user-friendly manner, it doesn't reach these people. So it's very important to develop these kind of, awareness campaign and this type of, user-friendly information. And if we have like website, people can have, like user-friendly chatbot where people, you have that kind of personalized conversation. This will help a lot. And on the other side, it's very important to work closely with the different regulatory bodies, this ensure so that we can ensure compliance with data privacy laws and regulation that is specific to the country or to the region. On the other side, to address this challenge, it is very important to implement strict ethical guidelines for, the data usage and AI application. We do have for, for digital information, etc., but maybe specifically, designed for these AI application, and at the same time to have the trust of people for this type of system. If we have these regulation, people maybe will trust more the system. Another thing that is important when we see people develop AI application, we should have what is known as the continuous communication. We ask the consent of the user should know what is happening. So we should have this mechanism. People see what you're doing. And let's say in the middle of the work, I want to withdraw my consent or to review my consent, I should be allowed to do this. So these are the main challenges, and how I think we can address these challenges.
Okay.
How we can address these challenges, right?
Yeah, clearly that person doesn't think we can, but let's see. But I was also wondering if maybe this brings up the other question, right? Like when it comes to traditional products, like for instance, if I go out and buy a bottle of baby powder, there's an expectation that it's not going to cause cancer. I don't need a contract to establish the fact that it's not going to cause cancer. But are we perhaps holding AI and generally the tech companies to a much lower standard, where we are possibly allowing them to decide what these standards of expectations are going to be based on these long contracts rather than broad accepted default consumer protection principles? But maybe that's something we can dig into as we go further into the conversation. But let me invite another household name, Jean-Michel Felix. Given your experience with MCB Consulting, and given that increasingly AI is getting integrated into the banking and financial sector, what would you see as your envisioning for responsible ethical adoption of AI for the industry as such? And really the question we're trying to respond to is, how do we enhance consumer experience, right? For the financial sector, how do we enhance consumer experience at the same time maintain privacy within those protection boundaries?
So easy question, but difficult answers, given also that all the panelists before laid strong foundations on what needs to be done, agnostically to any industry. So I won't repeat what has been said, but I'll just say that what has been said is accurate and complete. So my small nuance in what has been said up to now is, first of all, I think we should stop talking only about customers' experience. We should be focusing on total experience. And total experience will include, obviously, customers' experience, but will also include the needs for regulatory compliance, the whole ecosystem within the organization and society at large, given also all the talks about ESG and the protection of the environment. So that's my first take. Let's focus on total experience and not just on customers' experience. Because if you look at the financial sector and you take one particular example, the KYC, the onboarding of customer, and I think one of the panelists earlier on talked about passive frauds and issues around onboarding. If you leave the choice to the customer, who would like to be giving its utility bill every 6 months to a bank, whether hard copy or soft copy? So it's a boring, tiresome customer's experience. So any digitalization strategy focusing on AI, but giving the entire voice to the customer would lead to doom failure, because regulatory needs will not be fulfilled. So this is why, again, for this small example, I'm stressing on the need to focus on customers' experience. Secondly, I would say with the AI, you talk about the black box. It's true that no one masters the entire possibilities around AI and the different phases of AI. But when we look at movies in the past of like Terminator, this morning someone was talking about biotech arms and ends. This is coming, this is there, Internet of Bodies that I was been talking about. So at the end of the day, I firmly believe that the differentiating factor would be around trust. Trust in the regulatory framework, trust in the private sector, trust in the benefits of AI. And if I'm a sports freak, so I need to take an example related to sports. For those who know, there's the VAR, the video assistance recording, that is supposed to help specific sports to erase completely errors. If this has been heavily used in rugby, in baseball, but also in football very recently.
And cricket.
Okay, and cricket, right. Oh yeah, that's true. But we look at what is happening recently in England, where there's the Premier League, supposedly the best league in the world, but the richest league in the world, because it's a money business at the end of the day. Every weekend, there's an issue with the VAR. And technology was brought in to erase human errors. But technology was brought in to erase human errors without focusing on the people at the end of the day. Errors that are happening every weekend are linked to miscommunication, right? People not communicating to each other. And this will lead to a serious breach of trust in the technology, but also in the industry, because we all know there's money, a lot of money. There are people's lives at stake because they're jobs. So we really need to focus on this trust aspect. This inevitably would imply that all stakeholders need to work together. If this is not done, doom failure again. So when we talk about all stakeholders, we are talking about the regulators, we are talking about the private sector, but society at large. You talk about the education side. And if we take another analogy, Mauritius is top, amongst the first 3 countries in terms of road accidents. I think it's one of the highest death rate per square kilometer in the world. Do we do enough in terms of safety education? Yes, we do. But the results are still there. Still, we have a lot of people drinking and driving at the same time. Do we have the necessary regulations? Yes, it's zero tolerance now. But does it mean that we don't have accidents linked to alcohol? So what this is telling me as a we need to be more mindful that we've same message and they don't understand it the same way.
Yes.
So doing the same thing will result in the same results. Now, when we talk about technology, we talk about AI, we talk about things that we've not mastered. When you drive a car, you see the car. You see immediately whether you're going too fast or not. You see the policeman alongside, but AI, you don't see. So we need to be much better in this education perspective and addressing, obviously, the nuance in the generations, the way they talk, the way they are growing, and what is important for them.
Thank you, Jean. Let me quickly move to see if there are a couple of questions, perhaps, around AI and policy. 2 questions at most. Yes. And then one at the back.
Thank you very much for these insightful discussions. My question to the panelists is, first, what are the potential risks of emerging technologies like AIs and Internet of Bodies? And secondly, how can an individual balance the convenience and personalization offered by digital services with the need to protect their privacy? Thank you.
Thank you. Should we take both questions or yes? The second question.
Okay, thank you. My question is based on automated decision making as a result of artificial intelligence. So we are saying companies are taking advantage of the advent of technology to do business conveniently through the use of artificial intelligence. So now the challenges are artificial intelligence driven applications are used either to direct or indirect marketing. So my question is, how then could the data protection practitioners protect customers or people from decision making as a result of automated decision making?
Okay. Esa, can I possibly come to you first? Are you able to work with the audio fine? Would you like to perhaps respond to the
Hello? Can you hear me?
Esa?
Can you hear me?
Yes.
Okay. So, sure, from the very interesting questions and things that we are combating every day in the field. And I really like how it transitions very nicely from what the previous panelist was talking about trust. And there is a very interesting distinction that is happening in the age of AI, which is where trust is starting to move from a very implicit aspect to a more explicit conversation. And when I say that, what I mean is that implicitly we have historically trusted. Am I still here?
Yes, you froze for a minute there, right after you said, I have something interesting to say. So maybe you can say.
Cliffhanger. So it was a very interesting conversation where we started from talking, where the previous panelist was talking about trust. And we've started to see that we are moving from a conversation of implicit trust. And this is whereby we've just trusted because a colleague or a friend of ours trusted a solution. And we are moving to an explicit trust model where we need to understand how the system works, how it makes its decisions before we're able to trust it. We lived in an age where verify is optional, and we're moving to a stage where we have to verify before we can trust, especially in the age of deepfakes and all of that. And when it comes to a lot of the risks, there is risks in terms of AI in of itself. As much as we're doing a lot of personification of it, it's not yet an independent entity. It doesn't have autonomy yet. It is still driven and guided and implemented by either a company or a set of individuals. And as much as we might be looking at putting accountability on the algorithm or the artificial intelligence, it's not quite at that stage. It's not a conscious being. So personifying it can be a very delicate conversation. We need to remember that there are still a group of people who are implementing and have given it a set of objectives. And that's where, in my opinion, the big lies. What is the objective of the implementers? And this is where we start coming to conversations around Instagram and Facebook, and their major focus being they want us to spend as much time interacting with their content. How can they make sure we stay on the app scrolling endlessly for as long as possible? If that is the objective that is put in place, then the algorithm will do what it can to ensure that, because that is the objective with which it was built. So the risk that comes in my opinion, is the designer of the algorithm. What was their objective? And what does that cause? Especially when we see right now the biggest power of development of algorithms lies in the hands of large corporate individuals whose objective is profit, or in government, whose typically we've seen a government's interest is in control over either their population or such. And there can be interesting things they implement, such as social credit systems, which has been explored in China, where you can explore monitoring citizens' behavior and deciding if that is in line with the country's moral and social values, and providing them with a social credit score, the way we've done for financial credit scores. And the level of invasion of privacy required to do that is significant, because you're just now constantly monitoring your citizen. What is their objective, and how does that relate to a citizen's freedom and rights of expression? And then when it comes to balance of personalization versus privacy, unfortunately, this is a big trade-off when it comes to AI, because the way I think of artificial intelligence is that it enables personalization at scale. If we look at the age of industrialization, as we went through different stages of industrial revolution, we see that at the beginning, everything was handcrafted, personalized, unique to each individual. Your clothes, your shoes, everything was specifically personalized. And then you had mass production come in. And with mass production, we had to get rid of personalization because it's very difficult to do it at scale. And if I'm not mistaken, there was the saying, I think, by Henry Ford, where part of their production line system was you can have a car in any color you want as long as that color is black, because that's what enabled doing it at scale. But with AI coming in, we can personalize, but still do it at scale, but only if we have access to a person's individual data profile and to understand how do they operate. So that's what enables that personalization at scale. And now that becomes a trade-off to an individual. How much do they care about that ease of use, that access? How much do I care about the fact that if you send me an email of an agenda for this conference, my Google Calendar automatically puts that in my calendar without me having to do it? Or if I get a flight itinerary, it's straight up in my calendar. I don't need to do anything about it. It's made my life so easy. I can tell Google to stop doing that, but then it's made my life a bit more difficult. And there's always going to be that trade-off of ease of use and those luxury comforts. And that's kind of the conversation that's happening. I'll stop there because I don't want to ramble too much.
No, thank you. So that's really helpful framing. We have about maybe 30 seconds left, so quickly, let me just go to both of you. Anything to add, Felix?
Yeah, I would think two things in terms of the challenges. You've talked a lot about the data consent. I'll focus on the data quality. The AI output will be as good as the data quality. It's about both accuracy and completeness. So without this, we can't do, again, everything, or worse, decisions will be distorted. Secondly, I would put emphasis on the importance of AI prompter. So with AI, we are saying that we don't need human beings, but in fact, it's a question of changing skill sets. AI will be fully optimized, will be fully used, as long as we have also excellent AI prompter who will be able to understand, review the algorithm and change them whenever we need to change them. So that's my 2 cents worth.
Thanks. I'm going to give you the last word. So anything on automated decision making or anything else you'd like to add?
Yeah, coming back to this, what you were saying, it is very important to have data protection framework. Because if we don't have the right data protection framework, when we talk about framework, it is everything, storing data, collecting data, transferring data, how you're manipulating data, how you're managing the data. So if we have everything in the framework, people will build the trust on the system and they will try to adopt the system. And on the other hand, when we are talking about development, okay, we have the AI application. While developing the AI application, the design principles, the implementation, etc., if we have the right, policy and framework, I think we will have better AI application and people will be able more to adopt these kind of application. Right. And one last thing is that people should have the choice. For example, if you have the bank card, right? Some people will use the card and then withdraw money. Some people do not even have the trust on the card. They'll queue up and then withdraw their money. So you give people the choice. Whenever they start to build the trust, and then whenever, they are comfortable with the application, then gradually you will see people will start to use the system. Right.
Thank you so much. And thank you for taking the time and for taking the energy to, okay, looks like they're going to keep at this, yes?
Keep you up. I'm Patrick Pennings from the Council of Europe. I just wanted to add one thing to the trust issue. Trust depends on your expectation. Mm-hmm. And if your expectation is to live in a democratic society that defends human rights and respects the rule of law, then obviously you need to put a number of safeguards in place to use that great potential that AI offers to us. But we also need to look at what the counterparts are. And there, the societal context in which artificial intelligence is developed needs to be well defined. We need safeguards in place with regards to data protection, with regards to cybercrime, with regards to artificial intelligence. And that we need to develop, I believe, with a multitude of stakeholders, whether that be business, whether that be government, whether that be civil society. And I think one last thing about Professor Jerry that intervened in the first part, he spoke about 4 elements of the development of artificial intelligence. We're adding a 5th one, which is the decompositioning of artificial intelligence systems, because we are now all in a boom of wanting to create, but there will also be a moment in time that we need to decompose. And I think that's an important element to add to that. Thank you.
Thank you, Patrick. Let me not hold us back any longer from our break, but thanks again. I was just beginning to thank you all for the energy you put into this. And there are so many conversations around this happening in Africa and Asia and the global south, the global majority. And I hope we'll get to play a role in shaping what this future looks like. Thank you so much.
Thank you. Thank you.
Thank you.
Ladies and gentlemen, another round of applause to our panelists. Thank you. So without wasting any time, shall we proceed for lunch? And kindly, can we be back here by 1:50? Thank you. Enjoy your lunch.